I'm here.
is,
Good morning.
good morning. All right. And this is a non-payment of rent case. What is plaintiff's claim?
Your Honor, the rent to retain is $4,098.92. The costs are $220 for a total of $4,318.92. And we're asking for a writ date of March 30th.
All right, Ms. Cornelius?
I spoke to Annette on this past Monday, and I confirmed with her yesterday. We set up a payment plan where I'm going to pay $800 today and every week until I am caught up. I just did not want to not show up and have a default against myself.
That's fine. Counsel, you're not aware of that, I presume?
Your Honor, I have to confirm that with my client, though.
What's my... I'll adjourn this matter out, and hopefully that can be put into some type of an agreement or a conditional dismissal. March 27th, 2026, 3 p.m.
Yes.
3 p.m. Ma'am, that's an in-person hearing.
Yes,
So
sir.
you'll need to come to the courthouse on that date.
I'm sorry for if it doesn't get dismissed, or if we do come up with, like, if it's put in right, because I did ask her for
If it's going
writing.
to be dismissed, that's fine, but you'll have to come down to the courthouse. Those are the second hearings are in-person hearings.
Right.
And so if there's something that's worked out, you'll need to be here at least to confirm the agreement.
Okay.
All right.
I appreciate you.
you.
Thank you, sir.
Thank you. Arbor Meadows versus James Malacha and Eve Malaka.
Again, Your Honor, Jim McCarlo appearing on behalf of Arbor Meadows.
Not checked in.
Malacha, they are not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right. Go ahead, sir.
The rent to retain is $3,839.54 with costs of $220 for a total of $4,059.54. And we're asking for a writ date of March 30th.
Judgment to the plaintiff. That's by default for possession, redemption amount, any amount requested with a writ issue in 10 days. And
Thank you, Judge.
files got it right. Augusta Woods versus Tia Bean.
Jim McCarlo on behalf of Augusta Woods.
Yeah, she's here. All right. Ms. Bean?
Yes, I'm here.
Okay.
To hear.
What is plaintiff's claim in this case?
We also have Samsung. All right, someone is sort of joining us. That phone is having trouble getting in. I'm gonna wait because it's easier to wait than have to give the advice of rights multiple times. Mr. Peck, can you hear me? Here's Stephanie Hoops. The Samsung phone just isn't coming in. All right, there's Stephanie Hoops, Ryland Hoops. Zane Peck, would you turn your camera on, please? All right, can you hear me, sir? Mr. Peck, are you in a moving car? I'm not gonna do this while you're in a moving car, so you have to pull over. I don't want to have a crash while we're conducting court. And it's like it's not important enough to come or stay in one place, you're moving. So you need to pull your car over before we start your hearing. In the meantime, I'm gonna tell the Hoops and Mr. Peck that you are tenants in a landlord-tenant case. You're defendants in a case. Both of these are landlord is asking for possession. In the Hoops case, they're asking the rent to be paid, and in the Peck case, they're asking that the tenancy be terminated. In either case, you have a right to have an attorney to assist you in the matter. If you cannot afford an attorney, you can hire one. Excuse me. You can hire one, and if you cannot afford one, you could see if legal aid would represent you or other legal representations. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days and pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. If your landlord has asked you to be evicted because you haven't paid rent in a residential property, you may be eligible for some emergency financial assistance from the Michigan Department of Health and Human Services, Neighborhoods, Inc., Community Action Agency, or if you're a veteran, you may be eligible for some veterans benefits. You don't need a judgment against you to get financial assistance. The summons and complaint are sufficient and you have received those. Mr. Peck, that doesn't apply to you because your landlord's not asking you to pay the rent. They're just asking you to move. You may be able to reach an agreement with the landlord by going through mediation, also known as alternate dispute resolution. If both parties are interested in that, the court can help set it up. Or you may be able to work something out with the landlord, in which case they could file what's called a conditional order of dismissal. Let's start with Mr. Rognus's case, which is entitled Jose Lopez Garcia versus Stephanie Hoops and Raylan Hoops. The name Raylan is a lot more popular now, maybe, than when you were born. I think there'll be a lot of kids now named Raylan. Anyway, Mr. Rognus, the arrearage is substantial. At the time of filing, it was $4,200. What is it now?
At this point in time, Your Honor, it's the sum of $5,100. Insofar as costs, there's a $55 filing fee. Personal service on both the Hoops totaled $121.60, and the statutory attorney fee of $75. The cost would total up to $251.60.
So total is $5,351.60 through March.
Correct.
Ms. Hoops, could you unmute your microphone? All right, this rent is substantially behind. It's $900 a month. Hasn't been paid apparently since last October.
Your Honor,
Yes?
Mr. Lopez has been charging us $1,400 a month. He was going to throw us out if we did not pay that. So we've been paying $1,400 a month all year, this last year. So I have to disagree with the amount that they say we owe. I think Mr. Lopez owes us some money.
So you're saying you've been paying $1,400 a month through 2026?
Yes, sir. From November of 2024. So from November 2024 to December, I believe, when the last month's rent was paid, we've paid him $1,400 a month. I didn't want to be
Because of
homeless.
a previous arrearage?
No, because he was going to throw us out. Our air conditioner broke, and he was reluctant to fix it. And he said the rent's going up, and if I had a problem with it, there's the door. And I wasn't going to put my kids on the street.
All right, so from November of 24 through December of 25, you paid $1,400 a month?
Yes, sir.
How did you pay it? By check?
Sometimes it was money order. Sometimes it was cash.
Did you get a receipt when you paid cash?
Yes, sir. I'm not entirely sure where all the receipts are. Every time I paid him, though, I got a receipt. He has a receipt book. Whether he has one or two receipt books, I don't know.
All right, then
But
you indicated you stopped paying rent now in December.
I believe it was December.
Well, he says it's November, but why
So
did
it
you
was
stop paying
November,
rent?
December, January, February. Miss Hoops was the main breadwinner. I was part-time delivery driver, stay-at-home dad, and she was planning on moving, and she had stopped paying rent so she could move.
Miss Hoops, do you no longer live at this address on
Correct.
Pamela Drive?
Correct.
So you moved out as of when?
January.
I have moved out too.
All right. That makes things easier.
I just haven't had a chance to turn the keys in to Mr. Lopez yet.
All right, do you have all your stuff out of there?
Yes, sir. There's a few things that I couldn't take with me, but it's boxed up stuff.
All right, let's see here. Andrew, I'm gonna use your numbers. I don't know if you sent me a judgment.
I believe that we did, Your Honor, send it over there on the 11th.
You usually do.
I can fax one over if you need me to.
Now, I'm gonna give you a figure to pay, but you don't have to pay it unless you wish to stay there. So if you've already vacated, do you have any objection to us picking a date like Monday? You'll be out by Monday and turning the keys?
For the Hoopses?
Mr. Hoops.
Yes, I've already moved out, Your Honor.
All right. So you just need to turn in the keys.
I could take the keys up to Mr. Lopez's work after I get out of work today.
All right. Now, let me repeat this. I'm not ordering that you pay any money. I'm
Okay.
ordering that you pay money if you wish to stay there.
Understood.
Andy, I have a judgment in the electronic file. Elaine, could you print the judgment in Garcia versus Hoops? I don't seem to have it.
Freezing though, across southern Michigan, with the clouds still around. Show you future jet.
Say that again.
Scared of those lawmakers who are in charge of actually getting the job done. How about this line of messaging?
Hey, sir, who just came in by telephone? Somebody's here by phone. Is that Mr. Hoops? Did I lose you?
No,
No, sir, I'm here.
Oh, well, who's 8012 who's talking in the middle of the court proceeding? I don't know who that is, but they're gone. Elaine, could you print the judgment that Andy sent? I don't seem to have a copy with the paper file. All right. Ms. Hoops, do you have any objection to the landlord taking immediate possession of these premises?
No, sir.
Mr. Hoops, do you?
No, sir.
All right, now I'm going to use these numbers and let me repeat what I said. This is through March. Rent is $5,100. $251.60 in costs for a total of $5,351.60. That's how much you have to pay if you wish to stay there. The plaintiff did not file a complaint for money damages. So if they're going to sue you for money, under oath. So right now, I'm not ordering that you pay any money. I'm simply ordering that you vacate. And I will put in here, defendant has no objection to plaintiff taking possession.
All right. That works.
Mr. Hoops, when you turn in the keys, you can turn those into Adolfo Lopez. He's gonna be at Maria's Restaurant here in Sturgis on US 12.
Maria's, okay.
Yeah, rather than to Esperanza.
Okay.
And they're gonna need a forwarding address from you too.
Alrighty.
All right, I put defendants have no objection to plaintiff taking possession. They'll turn in the keys. So we're not going to fight about money. We may not fight about it at all unless the plaintiff files either a small claims or general civil claim for money damages, in which case we'll address money. This is only about possession. So you turn in the keys by the end of the day, he will take possession of the premises and you all can go on about your business unless he files a claim for money damages. All right, so Ms. Hoops, do you have any questions?
No, sir.
Mr. Hoops?
No, sir.
All right, along with that keys, you need to give your forwarding address in writing. So you need to do that as well. All right,
The
thank you both for
Lopez?
being here.
Yes, sir.
Yes.
Thank you for your time.
Thank you.
All right,
Thank you, Your
okay,
Honor.
you're good to go. All right, let me remove Miss Hoops. Now, I've still got somebody in here, Samsung. I've got some of our next defendants, Mr. Beachy and Ms. Sudbury are here. What's your name, sir? Your microphone is on mute.
Brian Park. Can you hear me?
Yeah,
Or,
this is Ryan Peck.
yes, sir.
All right.
That's who you have as Zane Peck around.
Well, I have Zane and then I have Ryan Peck.
Yeah, it's my son Zane's account that works through Zoom. I'm on a business
All right, well,
trip. And
all right, you're right, but who's the other guy in the
that's,
truck?
this is me, Ryan. I'm passenger. I'm on a business trip in Illinois.
All right. Well, who are you with a headset on? What's your name?
Mark Thrasher. I got a 9:20 appointment.
All right. All right, that's Mark Thrasher. No, I got somebody else in the waiting room. All right, someone who was here before, telephone number ends in 8012. Who am I speaking with? You've joined our live stream with a telephone number, and I don't know who you are. So could you tell me who you are? Phone number 80, they're gone again. Mr. Peck, let's pretend like we're in a court proceeding. Keep the camera on. You don't eat or drink anything while we're doing this. And we'll take it up. All right, we kind of bumped our way through the first case. We've gone through the rights with Mr. Peck, and we'll address his case, and then we'll take up our next one. Mr. Lance Thornton is here with me live at the courthouse on this matter on behalf of Borgert Family Farms against Ryan Peck and Zane Peck. Zane Peck is not here, but Ryan is. So both are there? Okay, Zane and Ryan, both defendants are present. This is filed as a termination of tenancy action. Mr. Thornton caused to be served on you a notice to quit on January the 2nd, asking you to move by February the 2nd. You didn't move, so he filed this action. There is no lease that I could see here. And at this point, Borgert Family Farms LLC wants this property back. Is that correct, Mr. Thornton?
That is correct, Your Honor.
Mr. Peck and Mr. Peck, what's your position?
I had a conversation with Keith Borgett last night. I farm for a living. I have a lot of equipment there. I had a good deal with Keith, and then the mother Doris passed away and everything changed, which I understand. But I talked with Keith last night. He told me to see that he thinks June 1st, I'll have everything out of there. And that's what Keith also thinks is there. And he's a Borgert. He's the guy who originally got the property through.
Well, he's not the owner of the property. The property belongs to Borgert Family Farms LLC. This happens a lot when the patriarch or matriarch passes, that's left to the kids. And then there are issues regarding that. They want you to move, not June, but now. What kind of stuff have you got there? Like major farming equipment?
Yes, I run my farming establishment out of there. So everything is there, and I have a place coming up April 21st. It's Oswald Farm. The father passed away, but they had to wait the 4 months. You know, he inherited it. So it's gonna be April 21st before we can do anything there. So, and I talked with Keith, and he said he's gonna talk to Cindy, the other Borgett. And he said he couldn't see why June 1st was a problem.
Well, they can certainly agree to that. There may not be agreement among the siblings as to what to do with this. The good news is we have to adjourn this matter at least 7 days. But this is more than just moving you and your bed and television out of there. You got lots of heavy duty farming equipment. So they're outbuildings, barns, that sort of thing.
Correct, Your Honor. And they're full. I mean, I've got 17 tractors there, 5 semis, my combine, my planters. I mean, everything for a farm is there. And I don't quite know where to move it to until
And
April.
you never had a lease?
No, me and Keith are good old country boys, and a handshake is what I go by, but I will never do that again. So,
The unfortunate part, Your Honor, is Keith Borgett never had authority to rent the premises.
and he told me he did, and you know, I've been there 2 years and nobody's ever said a word until Doris passed away.
Did you pay rent
Yes, $3,300 a month.
to Keith?
Yes.
Well, that's a pretty good deal for him. All right, well, this is complicated. As Avril Levine says, we're going to continue this to next Friday. Now, how is Borgert Family Farms LLC and Keith Borgert getting along?
Okay, the actual operating manager is Cindy Borgett of the LLC.
Okay. Well, perhaps they can work out some sort of agreement that he agrees to get his stuff out of there by a certain date, more than just 10 days from now. But today is the 20th of March. I'm going to continue this to next Friday, the 27th of March. That will be in the afternoon because we have pre-trials that morning. How about 1:45 next Friday, March 27th?
That works for me, Your Honor.
That works. I'll be back from Illinois Monday.
Now, in the ensuing week, it'd be very helpful if you and Mr. Thorne and all the Borgerts got on the same page. There could be some sort of agreement where they would issue a conditional order of dismissal. I'm just pulling this out of the air here, but let's just say you agree to move by June 1st. And if you move by June 1st, they could dismiss the case. The worst case scenario is you'd have 10 days from next Friday, March 27th, to move out, which would mean 17 tractors, 5 semis, all your equipment would have to be removed from there by April 6th.
Right.
Now, that's not a good solution, because if you don't move it, the sheriff's not going to come out there and remove all that property. This is something that needs to be done by you. But as you indicated, you have no lease, you have a handshake agreement, and he's not the owner of the property. And $3,300 a month times 24 months is a lot of money. And I'm not sure what all that's about, but how many acres do you farm?
Close to 3,000.
Where? All over there in Colin Township?
All the way east of Colin, Farron Road. East is our farthest, clear north of Fulton, Michigan, to Vicksburg, to Centerville, kind of all around.
All right, well, you don't just pick that up like a suitcase.
No. I got to have a farm to go to, you know, and I'm trying to find one, and they're kind of hard to get nowadays. And
Yeah, that's certainly true. All right, well, Mr. Thornton does agricultural stuff, and he knows the territory, and perhaps some agreement can be worked out. But at this point, in order to start the process, they've served this notice to quit and had this hearing. So we'll revisit this next Friday. I said 1:45, and I'm not sure that's what I meant.
when I get back, I can sit down with Cindy and Keith and I think Cindy and Keith are no problem. It's Sue Roach that I'm being told is the biggest problem with all this.
Is Sue Roach a Borgert or she's just a real estate agent?
She's a Borgert by, yeah, she was born a Borgert.
One thing we learn around here is everybody's related to everybody else. So, at any rate, you guys have got some work to do between now and next Friday afternoon, and we'll see what our posture is at that time.
Did we stay with 145?
Yes, 145.
And I'll
All
be
right,
there in
thank
person this time.
We had a special live appearance from Mr. Thornton because he had to be over here in Centerville anyway. So you guys are welcome to come live, or you can zoom in like this again next Friday afternoon.
I'll be there live because I'll be back.
All right, thank you.
All right, thank you, Your Honor.
Thanks.
Oh, that is complicated, but we'll see how we do. All right, we've got thank you, Mr. Thornton. We've got John Beachy and Megan Sudbury. We've got Mark Thrasher, who's a plaintiff. We've got Hot Pepper HPP. I don't know who this is. Who's Hot Pepper HPP? Good morning. What's your name? You'd unmute your microphone. I'm going to retire and teach people how to unmute their microphone as a career. All right, Thrasher is next, and then Beachy, if I can figure out who this dude is. Hot Pepper.
I don't know who that is.
Well, I don't expect it. Maybe you would. Oh, good. What's your names, please?
Lionel Ballard.
What's your name?
Lionel Ballard.
Oh, Ballard and Brown. All right, let me give you a name rather than Hot Pepper. You'd be amazed at what people have logged in here as.
Yeah.
All right, we can go on to our next couple of cases. Ms. Sudbury, Ms. Ballard, and Mr. Brown. And I guess that's it. Mr. Neff isn't here in Mr. Thrasher's case. You are defendants in a landlord-tenant case. In Ballard and Brown, it's a termination of tenancy. In Thrasher, it's a termination of tenancy. And in Beachy, it's a termination of tenancy. In each case, your landlord wants you to move. You have the right to hire an attorney in that situation. If you cannot afford an attorney, you could see if legal aid would represent you in this case, or you could seek other legal advice. You have a right to have the case heard here in St. Joseph County, right here where I'm located. The state Supreme Court says I'm supposed to tell you that, but it's never been an issue, not even one time, but it might be one day. Anyway, you have a right to have the case heard here in Centerville. You have the right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or make the demand in writing within 5 days of this date, file a written jury demand with the court, and be willing to pay the $50 jury demand fee unless the judge waives that fee for your inability to pay it. You may be able to reach an agreement by going through mediation. That's never happened either, but if both parties are interested, the court could help set that up with our agency, Citizens Mediation Authority, Inc. Or you may be able to reach an agreement with the landlord whereby the case would be dismissed with what's called a conditional order of dismissal if both parties are interested, counsel could help prepare that. So the first case that's actually set at 9:20, we're about 13 minutes behind, is Thrasher v. Neff. Mr. Mark Thrasher is here. Mr. Thrasher, you and I go way back.
No, you're
good
talking about
morning.
my brother.
Oh, your brother?
Yeah.
Your brother's also named Mark Thrasher?
Oh, no. Alan.
Well, I know Alan too, but you and I dealt with each other, I think way back in the 80s, maybe.
Okay.
But yeah, I know Alan as well. At any rate, you wish to evict Colleen Neff. She lives in your same house. And this says there was a bad breakup and there was no lease. She was personally served. She is not here. Is she still there?
She is still there. She just texted me a couple minutes ago that said that she cannot connect on. It says the phone just keeps hanging up on her. But she is watching.
Well, she may have been the phone number that kept coming in and I couldn't get the person to tell me who they were.
I think it was.
All right. Well, she isn't here. She doesn't have a lease. She was personally served and she has 10 days to move out. Has she begun anything to move out?
She started packing some stuff on out. She's getting a storage unit this weekend to move her stuff on out.
Well, calling and hanging up 3 times is not appearing in court. If she is watching, Miss Neff, he is the owner of the house. You don't have a lease. He wants you to move. He served a notice to quit on you on December 1st. It's now March 20th. He wants you to move and you have 10 days to vacate. 10 days from today is March 30th. I'm not ordering any money judgment. You have 10 days to appeal this or to file a motion to set aside the default. But in order to set aside the default, you have to show meritorious defense and a good reason for not appearing. Let's see who this is.
Says you tried 6 times that call.
Well, someone kept logging in with an 800-8402 and I could never get them to identify themselves and then they'd hang up. All right, here is someone who's logged in as Samsung S9. This is part of the reason why we're so far behind. We've wasted a lot of time trying to identify phantom people like Hot Pepper. Samsung S9, could you identify yourself? Well, I don't know who that person is. I have
that there was her. She's using my tablet. I have a Samsung 9 Android tablet, so I know that was her.
So, Miss Neff, can you hear me? She needs to learn how to unmute it, and then maybe we could. Miss Neff, can you hear me? Miss Neff? You have 10 days to vacate or you are subject to being evicted. I can't tell whether that's you. I'm treating this as a default. This isn't appearing, calling and hanging up or logging in with, I can't hear you or see you, doesn't qualify as appearing. So you need to unmute your microphone so I can speak to you. Mr. Thrasher, stick with me for a minute.
I ain't going nowhere.
All right, Ms. Sudbury, would you come up and have a seat right over here? All right, the next matter is file number 26311LT. All right, someone's there? Samsung? Who's speaking? They're very disruptive. Who is speaking? Someone's logged in as Samsung. What's your name?
Carolyn McNary.
Oh, Carolyn, you should be better than this at that.
This is only my second time, Judge. I'm sorry.
All right. Well, you're a boulder in the stream, but we'll be with you in a minute on those ambassadors cases.
Yes, sir.
All right. Thank you. All right. So we'll change her name in a minute. Anyway, this is John Beachy versus Megan Sudbury. I went through the advice of rights for Miss Sudbury. I learned about this case a couple different ways. Mr. Beachy is here in the conference room with his children who also live at that South Thompson Lane address. Megan Sudbury is here with me in the courtroom. There is a criminal case going on in this matter, and we had a pretrial on that yesterday, and I spoke to the fact that there would be a landlord-tenant hearing this morning. Everybody's here in a timely manner. There's also a personal protection order, which is Judge Pattison's bailiwick. I'm not sure how he got it. Anyway, Mr. Beachy and Miss Sudbury were living together in Mr. Beachy's home on South Thompson Lane Road. Domestic assault charge was lodged against Mr. Beachy, and he was compelled to move out of his house. Miss Sudbury was in the South Thompson Lane home with Mr. Beachy's children. At some point, she moved out of South Thompson Lane and moved into a property on Resort Road just across the lake. So Miss Sudbury, are you now living at the Resort Road address?
No, Your Honor, none of that information is factual.
All right, where are you living?
I'm not going to say on the record, but I do have a place. I have a lease. I can provide
All
that
right,
to you.
so
if I
you're
need.
not living at South Thompson Lane?
No, but that's because they forced me out, and his children were not staying there. He lied about that. His children were not staying there. They were staying with him. I believe they were at his mom's
So
house.
because of this, he and his children all had to move out of his house?
No, then he started sending his children back every day.
Well, it's their house.
Well,
So
it is their
at
house.
what point did you move out?
I didn't technically move out. I left because I am terrified of him and his children. I had documented things.
All right, well, so you're gonna need to get out of here. We just need to
I
figure out the
understand that.
details. So now, we were in dispute yesterday as to what is there. Is all your personal property still there?
Yes, but he said yesterday that it's not there. He also said yesterday that he had none of my property on his property, which is false. And I did provide the police report today because he had my gun and he did return it. Well, he surrendered it to Officer Morrill, who brought it to me last night.
All right, yeah, that was a bit cryptic yesterday, Mr. Beachy. You said her stuff is not there. Where is her stuff?
It's in the storage unit, Your Honor.
Your Honor, I have reason to believe that
Just
that's
a minute.
not all the way true.
Just a
because,
minute, just a
okay.
minute. Don't tell me exactly, but what town is the storage unit in?
In St. Joe County.
Who put it there?
The other people that were at the house.
Well, who are those?
My son.
All right.
I didn't return to my house till I believe it was January 30th, the week after she was out.
You can't do that. Violates the landlord-tenant anti-lockout statute. Whether you like it or not, she was a tenant at your residence and had lawful status to be there. Because of the domestic violence charge, you were in the odd situation where you got removed from your own house. It's a nice house. And apparently either your kids also got removed or agreed to vacate. But you can't take her stuff and just put it in a storage unit. The law gives her certain rights as a tenant. And you were cryptic about it. Now we've got this criminal case and this PPO. But the bottom line is she can't live there anymore. This relationship is ended. She doesn't have a lease. You live there with your kids. The prosecutor asked me to forestall the termination of tenancy case. And I really am not willing to do that. But we need to figure out how to get her and her stuff back to her. So when we talk about your stuff, are we talking about clothing and personal effects, or are we talking about
All
furniture?
personal items, all clothing of mine and my daughter's. I'm gonna say I probably had $5,000 to $7,000 just in shoes.
I bet I have $200 in shoes.
May I say something, Your Honor?
Yes.
Miss Sudbury was made aware that she could have all of her belongings. All I wanted was my items that she took from my house, like my wallet, my car key, my BMW car key that cost me around $780 to replace it because she wouldn't return it. Plus other items.
That came up yesterday. He contends that you took his wallet with his identification, his charge cards, and some of his personal property like car keys. There is a statute that allows the landlord-tenant judge to deal with personal property. Judge Stutzman had a different view of it in a case, but so, and you denied that. So do you have any idea what happened to his wallet?
No.
Nobody's under oath here, so I don't know what the truth is.
She was left in my home when I was arrested, and my kids would never take my wallet, so she was the only other party in my house when my wallet ended up.
All right, so after you went to jail, your wallet disappeared?
Yeah, along with
From your
my
house?
keys. Correct, along with my keys, a pocket knife I had, which mysteriously she ended up producing and giving to my brother and sister-in-law. But they were all together with my wallet and my car key. And my car key and my wallet were the only things that weren't returned, but the other things were, because they were always.
All right, well, I'm not sure what to do with that, but all right, Miss Sudbury, what do you want? What would you like? What would be the best outcome for you?
I would like my personal belongings back. I would like my daughter's things back, and I would like to get out of his home. I would like to do so when they are not present. Because I am terrified of them. I have many recordings of his children beating him up. So I am terrified of his children. And Daniel did tell me he is going to, and this is why I left, because I'm afraid of them. Daniel said him and his dad are going to take things away from me and punish me every day until I leave. When we were in Judge Patterson's room for the PPO matter, his attorney, Cyber, had specifically asked if they could lock me out, and Patterson said no. He said, you cannot do that. So that very same evening, that's exactly what he did.
Well, there's an anti-lockout statute, and you have some remedies under it. But at this point, you just want to go into their house while they're not there.
I don't have a problem with with peacekeepers, and that's what the officers told me to do. And they told me to break in because that's my residence and it's not malicious destruction of property. I didn't want to harm anything or anyone. I don't want anything to do with their things. I just want mine back. I am afraid of them. I don't want them present. I mean, John's not supposed to be around me anyway, but I definitely don't want his children there.
Well, it's their house. His children don't have a no contact order against you. He does. And that's their house. It's been their house for 15 years. You moved in less than a year ago and everything went sideways and everybody's life is in turmoil. But
can I say something else, Your Honor?
Yes, well, in for a penny, in for a pound. Yes.
I'll gladly pay that pound. This isn't the first time that Megan's done this to an individual. She did this exactly.
All right, we don't need to go down that path.
I'm just thinking that it's not her first go around doing this to somebody.
All right, well, I'm only gonna deal with this. Now, you've got her stuff secreted somewhere and you won't even tell me where it is other than it's in St. Joseph County.
It's in 3 Rivers, Your Honor. All I want is my things back and she's been made aware of that. I just want my things and she can have everything of hers. I don't want.
I don't have the authority to give your things back. Not in a context of a landlord-tenant case. I have authority to give her stuff back. Your theory, and it is plausible, is that she took your wallet and your car keys and your knife. And she gave your knife back to your brother, but you don't have your wallet, which has your identification, your credit cards. You had to pay $750 to get a new set of keys for your car. Obviously, the most important thing you want back is your wallet. I don't know whether she has it or not. She says under oath that she doesn't, not under oath, that she doesn't have it.
She took it.
I'm just trying to get her stuff back to her. Now, she contends that she still has items in your house. And she wants to go in your house without anybody being there and maybe a police officer, but they don't like to do this. Like, we have better things to do than stand around for 3 hours while somebody moves out of someone else's house. And we don't know what property is hers and what property is his. So if the sheriff will do it, great. The way it really works is when you move out, you're supposed to turn in your keys and give your forwarding address in writing within 4 days of your moving. Samsung, we still haven't figured out who you are. Who are you? I'm going to put you in the waiting room because you are very distractive. What's your name? Oh, that's Carolyn. Miss McNally, I'm going to put you in the waiting room because you're making a lot of background noise.
Done anything.
Hey, Judge.
Yes.
She's talking to me and said that she's unable to connect.
Who is?
Colleen Neff.
Well, she isn't here.
Yeah, it keeps hanging up on her.
You're free to go. She hasn't managed to log herself in. She has 10 days to vacate. Calling you on the telephone or hanging up on me 3 times or attempting to log in. Now, someone is here as iPhone. Who is that?
That could be her.
Are you Carolyn Neff?
iPhone is Carrie Bartholomew.
All right. That's the other thing I'm going to teach people to do is how to give their name on there.
So I'm free to go.
Yes, you can tell her she has 10 days to move out or she's subject to being evicted.
Okay.
All right.
All right. Thank you.
All right, back to Beachy and Sudbury. The law says we have to adjourn this matter at least 7 days. Mr. Beachy, what you need to do is allow Miss Sudbury to get all of her stuff out of this storage unit that you put it in. That violates the Landlord-Tenant Relationship Act, and violates the lockout law. She can actually sue you for money damages. We aren't there yet. I'm just trying to get possession back. You need to make this storage unit available to her to get her stuff out of it.
Your Honor.
Yes.
He also previously hauled a whole bunch of my items off of his property when I was still there, in an enclosed trailer. That has been gone for quite some time, and there are $2,000 worth of bikes in there. So I'm assuming, maybe I'm incorrect for assuming, I'm assuming those things have not been put in the storage unit.
You also have a trailer full of her property?
No, Your Honor, everything of hers is in that storage unit.
Including the stuff that was in the trailer?
Yes, Your Honor. That way she had no reason to come back to my house. Because she was packaging up some of my items in hers when I was not at my residence.
Well, this goes under the category of it's your own fault, everybody involved. She moved in, there's no lease, there's no marriage, your kids are there, the relationship goes south. You can't just pick all her stuff up and throw it out in the street, which is essentially what you did by putting it into storage. I want to get her out of there so she can get her new tenancy established. You and your kids can get your house back. So the first thing we're going to do is you need to make the keys to the storage unit available to her. Are you at the Resort Road address?
No, I was not living there. I did stay there for 2 weekends and a couple nights in between, but I never lived there.
All right, what town are you living in?
Three Rivers.
Where, I hope it wasn't at Menards when all the roof blew off.
No, but I do have concerns about the storage unit being one of those that was demolished.
All right, where is her stuff?
It's on MC. I don't recall what the name of it is.
All right, we need to get the keys to her so she can get her property out of there.
We'll do your.
How do we accomplish that?
I'm flexible. If he can get them to somebody and give the location and the unit number and I have access to get in, I'm sure it's a gated community.
Yeah, I'm sure it must be. There's a,
I mean, he can give them to anybody and I'll get them, not his children. Though.
Is there an intermediary person?
I mean, can he bring them to Kendra?
Yes, he could bring them to the courthouse.
My son Daniel can give them to her.
No, I would prefer not to have contact with.
Why don't you provide the keys to the victim advocate at the prosecutor's office? And then she can coordinate.
One more thing, Your Honor. She was in possession of my key when the police were first called on January 8th. She was in sole possession of that $780 key.
All right, well, we'll see where that goes. It's difficult to deal with that as part of a landlord-tenant case. This is a divorce without a marriage. She wants all of her stuff back. She wants her property back. You claim she's got some of your stuff.
She does, Your Honor.
It's all a bit complicated. So you're going to have your son, or you're right here, provide do you have the keys with you now?
I don't, Your Honor.
Well, it would sure be handy if you did. You could simply hand them over right here. but we'll have you provide, is that agreeable with you, Ms. Ackerman?
Yes, it is.
All right, the prosecutors, victim advocates are involved in the case from the other aspect. And that would be a good intermediary for the exchange of the keys. Then you need to get in there. And I don't expect you to move everything out of the storage unit, but see what's in there.
Yeah.
Because he claims there's nothing in the house.
I guarantee there is. I'm pretty sure he didn't grab my life jackets. He's got a whole bag of cannabis in his garage. I'm sure that he did not. I have pants in his laundry room, stain remover in his laundry room. I know that those are minor petty things.
Yes, they are.
But there were things in his home that belonged to me and my children.
Cannabis, I was unaware of any cannabis in my garage.
He's lying. He's the one that showed me the bag. He actually pulled the bag out of the dumpster because I put the bag in the dumpster. He pulled it out.
You know what? This is terrible.
It is terrible.
Stop. I don't want to hear this. I don't do divorce work. You need to get out of there. I don't want to fight about the Tupperware and life jackets. You're going to turn the keys over to the prosecutor's victim advocate.
Yes, sir.
She's going to get the keys and go in there and see what you've done with her stuff, which you lawfully can't do. You can't just take her stuff and put it in a storage unit, but that's what you've done. So I'm trying to unscramble it. So we're going to start by you getting the keys to the storage unit and see what's in it. This is not a small claims case or a general civil claim and delivery case. Let's assume she took your wallet and keys for sake of argument. I don't have the authority in a termination of tenancy case to order her to give your wallet back. I'd have to have a trial on whether or not she took your wallet. There's enough animosity here to last for a decade or two. I just want to get her stuff back and get everybody back to their own life. So you're going to turn the keys over no later than Monday to the prosecutor's victim advocate. They will then contact you and let you know that they have the keys. And then you're going to go get in there, and then we'll see what's what. So let's see what our next date is. I'm going to go 10 days rather than 7. I'm going to continue this to Monday, March 30th at 2:30. All right, let's recap. This is filed as a termination of tenancy action. Mr. Beachy wants Ms. Sudbury to vacate. She's already vacated. He has violated the anti-lockout law by removing all of her property. First thing she's going to do is she's going to get the key to the storage unit and retrieve her property. And then there'll be an issue about what is still missing. Theoretically, Ms. Sudbury, if he gets what he asked for, you would have 10 days from the 30th of March to have no possessory or tenancy issue in his house. That would be April 10th. So if you contend when I see you on March 30th that your property is still in his house, I'll have to make arrangements for the sheriff and probably Mr. Beachy's daughter to be present when you look for the house. Fight about life jackets and cannabis and a sack in the garage and stain remover. We just need to get you out of there. Then, if you believe he owes you money because he damaged your property, didn't return everything, you can sue him in small claims court for up to $7,000. Same thing for you, Mr. Beachy. If you believe she stole your wallet and your keys and it cost you expenses, you can sue her in a civil case for up to $25,000 or up to $7,000 in small claims court. This is a landlord-tenant termination of tenancy case. What it's about is removing the tenant from the property. Now, there's something called the anti-lockout law, which gives a tenant certain rights. The landlord violates that statute. And we're not going to get into that here today because there's no damage hearing. I just want to get you out and get you all of your property. And then if there's money issues, you guys can fight about that in a later case or simply get on with your lives. Now, we still have the domestic violence case, which is pending in criminal court. And that, I think, has a trial date in June. So that's much farther away than I would like, but that's what we've got.
I think it's April 30th.
April 30th?
I could be wrong. I put that in my phone
All right,
yesterday.
that may be the date I used. April 30th sounds right. That's a,
Thursday at 2.
no, that's a final pretrial. That's not a jury date.
Oh, sorry.
All right, so you will bring the keys to the prosecutor's office. They'll call you when they have the keys. So Ms. Ackerman, would you take Ms. Sudbury back to your office? Mr. Beachy, you and your kids can vacate and get back about your day. And we'll address this on Monday, March 30th at 2:30.
Thank you, Your Honor.
All right, thank you. You stay where you are for right now. Why don't you go ahead?
Thank you. Am I dismissed?
All right, you're good to go.
Thank you.
You want me to stay where I'm at, Your Honor?
As soon as Miss Ackerman gets her back in there, I'll up to 20. All right. I wish you had those keys with you today. That would have made it easier.
Actually, Your Honor, my son does have them with him.
Oh, he does?
Yeah, so he's gonna go into his car and get the key and give it to the prosecutor.
Very good. Very good. All right. Why don't you go do that now? And then your son, why don't you have your daughter do it?
Okay.
And turn the keys in at the prosecutor's office.
Great. Thank you, Your
All
Honor.
right. I'll see you in 10 days. All right. Again, we got some clinkers here. Mr. Nate, Mr. Werber, thank you. But we're behind in our landlord tenant docket. And we're gonna take up a couple matters. Ms. McNary is here on behalf of Ambassadors for Christ Church. The esteemed Robert Dutka is here as their counsel. We're gonna start with Ballard and Brown. They have been advised of their rights, so we'll do that one first and then see where we are. This is file number 26376. Ambassadors for Christ Church versus Linnell Ballard and Linnell Brown. The plaintiff wants the defendants to vacate from the room that they're wow, that's a blast from the past.
Judge Patterson just said, I know you, how do I know you? I said, oh, yeah.
I'm in the middle of a contested landlord-tenant hearing. The world famous George Horn just stopped in from South Bend, Barnes and Thornburg, but I'm in the middle of it. I don't know if you're going to be here for a while or you're.
We gotta wait for talk to somebody over in Judge Patterson's courtroom.
All right, well, I'll catch up with you in a little bit.
All right, very good, thank you.
All right, Mr. Dutka, like you, he's a graduate of White Pigeon High School.
Yeah, perfect.
All right. Anyway, let's do some real business. Miss Ballard and Mr. Brown, they want you to move. What's your position?
Yeah, we're trying to move. We're gonna move whenever you tell us to.
Okay. The law says we have to adjourn this matter at least 7 days for you to have the opportunity to seek legal advice. Today is the 20th. Next Friday is the 27th. It's going to be the first Friday of the month. So I set 1:45. Mr. Dutkar, are you available at 2 o'clock on Friday, March 27th?
Unfortunately, no, Your Honor.
Well, can we go to Monday then?
Oh, perfect. I'm free Monday, the 30th.
All right. I just did one at 2:15. Let's do this at 2:30 on Monday, March 30th. Now, Ms. Ballard and Mr. Brown, what would happen if they get what they ask for? You would have 10 days to move out after March the 30th, which would be April 10th.
Okay.
So if you don't move by April 10th and they get what they ask for, you could be subject to eviction where the sheriff comes and puts all your stuff out. So it sounds like you're working on moving.
Yeah, we'll be moved by March 10th.
All right, well, we got a hearing, March 30th. Mr. Werber's doing his yoga exercises.
Yep.
All right. Now, if you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. And if you move before the 30th, well, you don't need to be here for the hearing. But if you're still here, we'll address it. And then I would give you 10 days from that date to vacate. All right. Do you have any questions?
Nope.
All right. Monday, the 30th at 2:30. All right. I'll see you then. All right.
All right. Thank you.
I'll remove you. All right. A little bumpy ride this morning. Next, we have Ambassadors for Christ versus Null and Void. James Null, 26377 LT. He is not present, but Carrie Bartholomew is present. And Miss Whitney, which case are you here on?
Hang on, I gotta look at the paper here.
He's on the case I'm on, Your Honor. It's the portfolio recovery.
Mr. Werber's case.
Whitney matter. It's just her motion for installment payments.
All right, yes, I have Kathy Beach.
And the beach matter is on mine, Your Honor.
And Mr. Nate is here on Kathy Beach. She is not present.
That one will be quick. I don't know if she's planning on appearing or if counsel is, but we do have a consent judgment.
Let me call it. Let me call it.
Yeah.
This is LVNV funding versus Kathy Beach, 252464 GC. This plaintiff's motion for summary disposition. This matter was set for 10 o'clock. It's now 10:12. Kathy Beach is not present. Mr. Preston Nate is here for the plaintiff. They do have counsel, Sonny Miller of Farmington, Michigan, Robert Gitmead and Associates. Mr. Nate, what do you know?
So we did get this one resolved, so we will not need to move forward with the motion today. We do have a signed consent judgment. It sounds like it probably didn't make its way to your bench yet, so I can make sure we resend that or make sure the court gets a copy of that, but this one's all resolved.
All right, very good. We're moving. We're vacating everything in this building, 50 years worth of stuff out so they can do construction. So the staff has been preoccupied. We've been actually closed for a couple days. So we'll find that. If we don't have it, we will look for consent judgment or request it.
Yeah, that'll be fine.
All right, thank you for checking in to let us know what the status was.
You bet. Thank you, Your Honor. Appreciate it.
All right. All right, Laura, I left the Janice Whitney case in my office, I think. Because I can't find it. But in the meantime, we're going to do Ambassadors for Christ versus null and void. File number is 26377LT. This is filed as a termination of tenancy. Defendants were personally served. Defendant was Mr. Null. Mr. Dutka, what's the status here?
Last I checked with my client, I believe he still occupies the premises, so he not being present, we'd ask for judgment to be entered.
Ms. McNary, is he still there?
Yes, he is. Can you hear me?
Yes, I can hear you and see you. We're good now.
All right.
All right. Well, he was personally served. It is a termination of tenancy. He had the keys.
I had Megan in my office and hadn't had a chance to speak to Misty yet, so she sent her down to district court. Now I don't know where the young lady is.
Who?
John Beachy's daughter. I'm unsure for me.
Well, she supposedly has the keys. Elaine or Michelle, did she show up there with the keys? I found it. Thank you.
Okay, I have.
All right, very good. All right, you're good to go. Thank you. All right, I got a lot of plates spinning here. Mr. Dutka, let's see if I have a judgment in here.
Hopefully, Your Honor, I did leave one off yesterday, but I realize, yeah, the court is in flux, so to speak.
I think Elaine gave me several judgments. All right, we'll do a default. Defendant has until March 30th. To vacate and appeal. I believe I have a copy of that judgment. Elaine had it for me.
I have some up here and they were with the other paperwork. And no one dropped off the key yet, so.
I think they got it squared away.
Oh, okay.
Laura, did you need our office's assistance?
I think we've accomplished it.
Okay.
We were trying to get the keys for the storage unit from Mr. Beachy to Ms. Sudbury.
Okay.
And Kendra was willing to assist with that, and we have done that.
Okay, perfect. Thank you. I just wanted to check.
Well, I appreciate their help. She was on top of it and they were here. So I think the next step is she's got to get her stuff out of the storage unit. We're not done fighting about it yet, but we have a hearing set for next Friday.
All right, thank you.
All right. So no, he has until 3/30/26. Oops, that's a default. All right, Miss Bartholomew, you stay with me for a minute. We're gonna switch gears for just a second. Mr. Dupke did have the judgment.
Very good. Thank you, Your Honor.
Thank you. All right, Ms. Bartholomew, we're going to come back to you in just a minute. In the meantime, however, we're going to skip to a general civil case, which is entitled Portfolio Recovery Associates versus Janice Whitney. The file number is 251216GC. On behalf of Portfolio Recovery Associates is attorney Jeffrey Werber. This is a claim that was entered with a judgment in the amount of damages of $4,773.13. Defendant filed a request for installment payments of $75 per month. And that's a large debt for $75 per month. So what happens is you file the motion for installment payments, plaintiff objects to the amount, end up chasing our tails. So I just set everything for a hearing to get everybody in the same place at the same time. Mr. Werber has a lot of experience in this area and represents his clients well. All right, so here's where we are. The amount due according to the order is $4,915.13. It may have changed. $75 a month. It's taken about 6 or 7 years to pay that off at that rate. Mr. Werber, what could the plaintiff accept in this case?
You know, Your Honor, I did look at the defendant provided a lot of information here. She gave all her bills. She gave her budget. To me, after looking at all this, it seems like 75 is going to be a stretch for her. Am I correct, Miss Whitney?
Yes, sir.
Yeah. So, you know, I know it's going to take 6 years, but I don't know if she can afford to pay anymore looking at everything. So,
all right. Well, if it's acceptable to you, it's certainly acceptable to me.
It seems like that's the route we're going to have to take because I don't think she can pay anymore looking at everything she provided. Now, I will say, if any funds have been, I don't know if any funds have been garnished from your paycheck. If they have, I'd ask that those go towards the balance. And Miss Whitney, I would tell you to take the order that I assume the judge is going to enter today to your place of employment as soon as possible to get the garn stopped.
Okay. Yeah, I have not. It hasn't been garnished yet, but I get paid Tuesday. So I'm assuming it will have caught up by then.
Yeah.
All right. I'm going to do this $75 every month starting April 1st. Do you have instructions on how to make the payment?
Yeah, Miss Whitney, you can mail us a check or money order. You can call us and make a payment over the phone, or you can go on our website, weberolseast.com, and make your payment there.
Okay. Is it from that paperwork you sent that said you were going to garnish my wages?
Yes, that address and everything is on the paperwork.
Yep. Yep. Just make sure you pay by the 1st of each month.
I will do the best I can. I have what I have, and I don't have.
And I tell everybody, if you can't send 75, send 50 or send something just to know that because otherwise they'll move to set the thing aside and garnish your wages, which will not be very good. No, so I will do this order effective today.
Do I pick up this paper from you, or, because I could take it into work tonight.
Well, if you come over to the courthouse, or I'll tell you what, you call the court here in a little bit, and they can email a copy of this to you so you can take it into work.
Okay.
All right. Let me give you the number to call. 467.
Wait, pen. Okay, 467.
5623.
Oh, that's Michelle, I think, right?
Yes, that's Michelle.
Okay.
All right, Mr. Werber, thank you for your appearing and for your grace to the defendants.
I
$75.
appreciate that. Thank you, sir.
Yep, I wish you the
All
best of luck, Miss Whitney, and Judge, have a good weekend.
If I had it, I would
All
pay
right.
it.
Yep, take care.
That was set for 10. It's now 10:24. It could be worse. Let's go back to our landlord tenant docket. And that matter was set for 9:50. So we're about 35 minutes behind, but our last Ambassador for Christ case is Ambassador for Christ Church versus Carrie Bartholomew. Carrie Bartholomew is here with us. Miss Bartholomew, you are a tenant in a landlord-tenant proceeding. Your landlord has asked you to terminate your tenancy and have you vacate this room you have at this property on South Main Street. As such, you have certain rights. You have the right to hire a lawyer. If you can't afford an attorney, the county could appoint one for you. Excuse me, that's a criminal case. If you cannot afford an attorney, you can see if legal aid would represent you or seek other legal representation. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first court appearance or file the written demand within 5 days and be prepared to pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. I'm doing a little house cleaning here. If you can reach an agreement with the landlord for some sort of agreed upon move out date, it could file something called a conditional order of dismissal. And Mr. Duck could prepare that. Or if both parties are interested, I could refer the matter to mediation for an attempted mediate settlement. That's never happened, but it might one day. All right. Miss Bartholomew, are you still there?
Yes, I'm still here.
Have you made any plan to try to move, or?
I have actually started moving. I'm almost completely moved presently.
Well, I'm going to adjourn this matter, continue it to March 30th. What time did I set Mr. Ducka's other case for?
2:30, Your Honor.
We'll set it for 2:35.
And I have contacted legal aid. I've been assigned a lawyer on this case.
All right. If you move, you turn in your keys and give your forwarding address in writing within 4 days of your moving. If you don't move, we'll address this further on March 30th at 2:35. And if legal aid is going to come in and represent you, so be it. This is a month-to-month tenancy. It looks like they were trying to get a lot of people out of this place. I think there's 6 rooms in this building. I don't know all the details of what's going on. If you just move and turn in the keys, they could perhaps even dismiss the case, which wouldn't
Right.
show as evicted on your record. So
Okay.
you stay in contact with Ms. McNary. If you move, turn in your keys. If you don't, we'll have a hearing on March 30th at 2:35.
Yep, I will be moved.
All right, thank you for your patience.
Thank you, Your Honor.
All right, thank you, Mr. Dutton. Ms. McNary, I'll see you again. All right, I'm gonna stop the live feed for a few minutes. Our next hearing is at 10:50, so we got about a 20-minute break here. He and I were adversaries on a murder case a number of years ago. Well, as soon as I get set up here, I'll deal with that. I shut everything off because I had a visitor, an old colleague, George Horn from Barnes and Thornburg was in town, and he stopped to say hello.
Nice.
All right, so nice to see him. He and I were adversaries on a murder case a number of years ago. All right. In fact, the case is so old, the defendant's out of prison. All right, we're back. A little bit behind, but not terribly. We're going to get set up. We got 3 cases left to deal with. Everything is well in Big Pine Key and Three Rivers.
Yep. Chili. And I
Good.
made chili today.
You like it when it's cold in Florida?
Oh, no. Larry likes it, but I don't.
It's the coldest in 24 years we've
All
had.
right. Miss Miriam, I'm gonna ask you to put your cigarette out. And we've got Samsung SM. Who am I speaking with? You need to unmute. I see you, Miss Miriam, but I've got another lady on the screen. Lydia, do you know who that is?
I do not.
It might be Enchanted Glen. It's Miss Cleveland, I think, is who it is. So we'll deal with her in a minute. All right, we've got 2 Richmond cases. Terry and Larry Richmond versus Marcia Merriam. Marcia Merriam is present. We were here last on March 13th. This is filed as a termination of tenancy case on a month-to-month tenancy. The plaintiffs want the defendant to move. Miss Merriam, what's your position?
Well, right now I'm looking for a place.
All right.
Because I'm disabled. I'm disabled now, so it's kind of hard for me to get around to find places.
Yes. And most of the places are non-smoking. If you were going to get into any subsidized place, they would be non-smoking. Well, this is our second hearing. You had indicated you were checking on a new place at Millard Court. But right now, you have 10 days to vacate, which would be March the 30th, or you're subject to being evicted. The written, you also have till March 30th to appeal this. The Richmonds do not have to evict you on March 30th. They have 56 days from today to ask for the writ of eviction.
Lydia,
Okay.
did Safe Built give you a time frame?
They, last I spoke with them, they were wondering where we were at with the eviction process. I told them that we had court again today. As far as I know, they originally gave us 30 days, but they extended it because of were going through the court. 30 days.
What are
where
you
they were
referring
going
to?
They're gonna post it, condemn it if she does not
Oh.
move out. So they gave us 30 days, but we asked them to hold off so that we could get her to move, give her time to move. That's why we filed the notice for eviction, so.
All right, Miss Merriam, you got, the city is about to condemn this, which isn't good. It failed inspection. And they want to bring it back up to code. And they started this process with a notice to quit quite some time ago.
January.
Back in January. And so you have 10 days to move or you're subject to being evicted. You do have 10 days to appeal this. I think Miss Bauer was here, but she's not here now. But at this point, they're under pressure from the city to have this property vacated. And here is Meg Bauer. So you have 10 days to move or you're subject to being evicted. So you should work on that property at Millard Court. Now, when you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving. All right. Do you have any other questions?
I'm just, like I said, I'm just trying to find people to help me move, and I'm not having no luck with it.
All right. I wish I had maybe you try with the city. The city is the one that wants this vacated. All right. Good luck to you, ma'am.
Thank you.
That's a tough
Your Honor.
situation.
It
All
is
right, we
terrible.
got one more. We got Richmond versus Dustin Shepherd. It's a damage hearing. It is 11 o'clock.
You don't need me for
This
I don't
is
think
file.
so. Thanks.
This is file number 252384LT. Terry and Larry Richmond versus Dustin Shepherd. There's a claim for damages. Ms. Richmond, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, sir.
I recall this case, and Mr. Shepherd, excuse me, that one sneaked up on me. That's the last one. You've provided a security deposit notice, and you do an excellent job of these.
Thank you.
And your amounts you charge are fair and reasonable. But let's start with the amount. Rent through December 20th is $2,384. Is that correct?
That's correct. And 28 cents, but
28 cents. Repair 2 broken window screens, $40 a piece, $80. Clean bedroom carpet, $40. Touch up paint, $50. Labor for cleaning and installing a front door and new carpet, $320. Replace solid wood front door, $180. So the total damages are $3,054.28. Is that correct?
that's correct, sir.
Elaine, do I have a judgment in here?
Oh, you might not have. I might have
I
forgotten.
don't see.
It's
Maybe
just a
Elaine
civil
could-
judgment, right?
Yes.
I'll get one
All
to
right,
you.
well, let's, then there's security deposit of $975. So if we take damages minus the security deposit, we get $2,079.28. Is that correct?
That's correct.
We got court costs of the writ, $157.13. Or $157.13, the writ of $15, Southwest Legal, $38.39. Let's add that up. 157.13 plus 15 plus 3839 is 210.52.
Oh, I got 2274. Let me check.
Well, let me try it again. 157.13 plus 15 plus 3839. 210.52.
Oh,
plus 207928. I got a different number than you got.
okay. What'd you
But you
get?
got 157.13, writ 15, Southwest Legal 38. Did you leave something out?
I don't think so. So you came up with how much? 2000?
38.39 is 210.52.
2000.
All right, so we had
Oh, that's the difference.
210.52 plus 2079.28.
Oh, I see what you're saying. So my judgment should be 2038.39.
It should be 2002. 2,289.80.
Okay. All right. I'll just, oh, that's higher than what no, it's not.
It's not, it's 2,289.80.
Okay.
All right, if you'd send that, we'll sign it and
Okay, I'll have Lydia drop one off.
all right, thank you, Lydia. All right, thank you. We're
Thank
gonna
you, Your Honor.
show as a default. Plaintiff will provide judgment. All right, enjoy your Florida Keys Day. We got a ways to go yet here in Michigan. You missed a bunch of snow, and you also missed the tornado.
I
Did any of
know.
your properties get damaged?
You know, for as many as we have, we fared very well. I think we had like maybe 4 trees on roofs, and they're all repairable. So it's just getting the trees taken down and getting the roofs repaired, and we're on it. So
Well, you're in for a surprise when you come back.
I saw some pictures.
Yes. All right. Thank you. And
Thank
I'll see you
you.
next time.
All right. Thank you.
All right. Next, we got Sturgis Housing Limited versus Sheldon Ashbrook. And I don't see anybody here on that case. That's set for 11.
I'm
We'll
here
set
for
that.
that.
Yeah, we don't, the attorney isn't here. No, Mr. Popovits is here. And then we also have Enchanted Glen versus Cleveland. It looks like the Sturgis Limited is going to be a default. Miss Cleveland is here. Miss Bauer is here. Let's call that case. Enchanted Glen versus Roche and Cleveland.
Hello, Your Honor.
Good morning. Manager from Enchanted Glen is also present. All right, this case has had several hearing dates. I got 4 pages of notes. The defendant was working on vacating, I think, and the parties were working on perhaps a conditional order of dismissal. Mr. Popovich, what's the status here?
Thank you, Your Honor. I appreciate the court scheduling of this matter on a weekly basis, given obviously the circumstances. Ms. Bauer wasn't here last time. She had a colleague from her office subbing in. There was a significant amount of discussion as to rent, arguments as to, or not even arguments, but testimony that was elicited from the court from the tenant and from the property manager as to processes involved as to assigned application and anticipated recertification, the status of that application. And we started discussing possible conditional dismissal terms regarding the tenant's vacation. If this tenant was to be vacating, then my client would be far more agreeable or flexible as to agreements as to rent amounts and things of that nature. We got to a point where I believe Ms. Bauer's colleague was a little uncomfortable. He had not had many conversations with the tenant, was just subbing in as a good coworker for Ms. Bauer. And I think that it got to a point where he wasn't comfortable sort of agreeing to a conditional dismissal or anything of that nature for the lack of understanding of the circumstances. Ms. Bauer is back today. We have not talked prior to today. I did try to reach out. I know Meg's probably very busy. I'm wondering if a breakout room could help for her and I just to sort of see what update she's received from her client as to possible vacation, and if that allows us to cut short some of the anticipated testimony regarding rent amounts, processes, things of that nature. I'm willing to meet.
All right, that's fine with me. Meg, what's your thought regarding that?
I just want to clarify a couple of things. First, Judge, there was no testimony taken. No one was under oath at the prior hearing. I also I don't have a record of Attorney Popovich reaching out to me. If I missed that, my sincere apologies on it. But one thing that was not discussed very clearly at the previous hearing was that the plaintiff filed for a money judgment in this case. And so simply swapping or consenting to possession, I thought Attorney Roberts, managing attorney, filled in on my behalf, made a good point about not just entering a number, because if this is a non-payment of rent case, the tenant should have the opportunity to redeem, but also in my review of the file this week, we requested the tenant file, and we did not receive the entire tenant file. So there are a lot of, I'm certainly not opposed to speaking with my colleague in breakout session, but I would actually request permission to view the file on the premises, because it is unquestionable to me that the file was incomplete. I have records transmitted by the plaintiff to my client that were not included in the transmission to me. And so at this point, I don't know what's being taken out selectively or not, among some other concerns. So I'm certainly happy to meet with Attorney Popovich and discuss this. Of course, the goal is resolution and to not waste the court's time. However, there are additional, this case is not as simple as meets the eye. And quite frankly, Ms. Cleveland doesn't have anywhere to go. This is subsidized housing. The subsidized complex has a duty to the tenants to do things right. And based on my review of the evidence, which if we go that far today, I am fully prepared to demonstrate. Not fully prepared, I am prepared to demonstrate, but the complex has not done things correctly here. And so we've got a terminally ill individual who's going to be homeless as a result of this. And we've got Ms. Cleveland, whose future is also at risk here.
May I, Your Honor?
Yes.
One, I've got an email, Meg, that I sent to you on March 18th at 10:32 p.m. asking you to reach out to me. So I'm not putting things on the record that aren't accurate as to my attempt to reach out to you prior to today's hearing. Agreed, there was no testimony. There was a lot of questions and answers, and that's what I was alluding to. The court did a very good job of filtering through the issue and trying to get information from both of the parties. So while there was nobody sworn under oath, I'm not trying to characterize it in a way that's not the way it occurred. You had a colleague here who I thought did an exceptional job standing in, but it got to a point that there wasn't a comfort level as to any agreed upon resolution. regardless, and I get the money judgment and I get the fact that he didn't feel comfortable with slapping a number down because he wasn't fully versed in the defenses and the potential defenses. That's why there was stakes pulled. And quite frankly, I was as involved as anybody in pulling back so nothing was entered discourteously towards you or your client, because I was the one who made the representations to the court that you should be here given your knowledge. I don't know that there was anything not included in the file. I'll send you whatever we have. It may have just been in a different, it might be cell phone communications or texts, and those aren't typically kept in the file. With you, I sent you the file. It was available for your client. We'll get you whatever else you need. Let's not overcomplicate this. And Ms. Cleveland is the one who continually has told my client or the court, represented to the court, that she's vacating. So any opportunities here for a quicker resolution and an amicable resolution as to an amount of rent that would be due and owing under a money judgment and a conditional dismissal for her to vacate is not the complex's doing of pushing or trying to make somebody homeless based on anything other than the legal proceeding in front of them, but based on her own commentary and actions on site that show she's trying to move. If she doesn't have anywhere to go, then she should stop saying to other people that she's moving, so we're not confused or thinking that's an option. And if we need to get you additional documents for a testimonial hearing, fine. But this is a non-payment, so ultimately we could put on testimony. The judge could figure out an amount that's due. She has 10 days to pay it, and she'll be evicted. I, above anyone else, try to work these things through a global resolution. I'm a little taken aback by the courtesies I showed a week ago and then sort of the demeanor here.
All right, stop. I'm not gonna put you guys in a breakout room because you're not gonna accomplish anything. You're just gonna snipe at each other. And so let me finish the default case. I had to be in Kalamazoo by noon. It ain't gonna happen. So we'll see what we can accomplish, but I don't think I'm gonna accomplish anything by putting you in a breakout room. So Mr. Popovich or Ms. Arnold, would you join us, please?
Judge, can I just make one brief statement?
No.
That I think is positive? Okay.
All right. Well, if it'll be helpful, fine. If you want the last word, then so will it help?
I just wanted to let Mr. Popovich know that I don't have any personal beef or frustration with him, and I appreciate his collegiality. That's all I wanted to say.
All right, fair enough. You guys have worked together on a number of difficult cases, and maybe we can get there on this case. Let's take up Sturgis Limited Housing versus Sheldon Ashbrook. The file number is 251782LT.
Thank you, Your Honor.
Attorney Rebecca Arnold is here. And good morning.
Good morning.
P72714.
Yes, that's correct, Your Honor.
And the manager, Mr. Grove, is here. Would you state your name?
Cynthia Graves. I'm here at Gateway. Sorry, I couldn't figure out how to take the Mystic Grove off of there.
All right. Cynthia Gaines.
Graves.
How do you spell that?
Graves. Graves.
All right.
I'm the assistant manager here at Gateway.
Would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
All right, Ms. Arnold, you've submitted an accounting. Mr. Ashbrook is not present. You're claiming, and Ms. Grove or Graves, I didn't spell it right. Anyway, that's close enough. Rent May, June, July, August, September, and a partial for October. The rent component is $6,748.
Yes, Your Honor.
Is that your intention? Cynthia, do you agree with that?
Yes, I will agree.
You've got late fees of $300 and damages of $471. Is that correct?
That is correct, Your Honor.
So if we had late fees, rent, and damages, I gotta redo this a little bit. 6,748 plus late fees of 300, plus damages of 471. We get 7,519.
That is what I have as well.
Now, do you agree that the security deposit would be 1,301.73?
Yes, that's also what I have.
Equals 6,217.27 in damages. Now, if we add the court costs of 414 back in, we get 6,631.27, which is the same number you had.
Yes, my math is the same.
6,631.27. And that's the amount that you're swearing to under oath is due and owing in this case.
Yes.
Miss Arnold, I don't see a judgment in here. Could you send?
Yes, for the money judgment, I can
Yes.
send that. Yes, Your Honor.
All right, I grant money judgment in that amount. We came to the same number a little bit differently, but damages of 6,000.
6,217.27.
Yes.
Okay.
6,217.27 plus 414 in court costs for a total default judgment of 6,631.27. $661.37. 6,631. Plaintiff will submit judgment. The easy part is getting the judgment. The hard part is getting any money, and this defendant probably is not very collectible, but you can send that to our email address, which is on the pleadings, 3bcivil@stjosephcountymi.gov.
Okay, I'll do that this afternoon.
All right, thank you.
Thank you.
All right, we've cleared the decks. I was hopeful. I set these two things closely together and I was hopeful to get out of here this morning, but we're gonna be here for a bit. So let's call Enchanted Glen versus Mary Cleveland and William Roche. Mary Cleveland is present. Is Mr. Roche also present? Where is he?
He's in Three Rivers. I'm thinking he didn't get a ride back home last night. Couldn't get a ride.
In Three Rivers where?
I'm not sure. He had to take the U-Haul back yesterday. And then he had to try to find a ride back home.
All right, is he moving stuff to Three Rivers?
Yes. Well, we have a locker in Centerville, actually.
All right, also the manager, Kim, is here. Would you please unmute your microphone?
Hi, Your Honor.
All right, good morning. Miss Cleveland and Miss Snow, would you please raise your right hands? You'll swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Absolutely. Yes.
All right, we've been at this since March 6th. We adjourned it from March 6th to March 13th and March 13th to March 20th. The plaintiff's allegation was that through March, the rent was $4,362, $313.45. In court costs for a total of $4,675.45. We spent some time last week trying to get to that figure. As I've said, no one was under oath. Mr. Roberts was here. Mr. Roberts has plenty of experience in this area, but he didn't have experience in this case, and he was unwilling to make any final decisions because of that. So as Ms. Bauer indicated today, there are a number of issues regarding recertification times and that sort of thing. And there were issues about William having income. William isn't here, which is not helpful because he's one of the defendants here, and he is also one of the sources of income. Ms. Cleveland, would you raise your right hand? Oh, I just did that. I swear you both. And as Mr. Popovich indicated, the defendant was in the process of trying to vacate, which makes the dollar amount less crucial if we don't enter a money judgment. Let's say, like say you owe $1 million in rent, or you have to move out, and you move because you're not going to pay $1 million in rent. I didn't make a finding that you owed $1 million. We would have a hearing. Let's make it more realistic, $10,000. We'd have a hearing at some point regarding how much money you did owe. This is set for both of those things. And so Mr. Roberts, I think, was reluctant to enter into any sort of agreement. So let me ask this, Ms. Cleveland, you're in the process of moving your stuff. Have you found anywhere to move to?
No, I've tried and I've called everywhere that every resource, every department. There are some.
That's
Go
why,
ahead.
Judge, that's why this matters more than just a possession judgment, because when she applies for additional housing, the first thing they're going to do is ask for references. That reference is going to be the prior landlord, who's going to then have to speak to the status of the account. So even if she consents to a possession judgment, that still dooms her ability to get future housing, even if there's no eviction judgment on her record.
All right.
I'm
from your perspective, how much do you believe the rent is?
It appears to me that the rent should have been $224 for the first from June until this apparent recertification effort for $212. Based on documents provided by my client and the same document provided by the plaintiff, there is a form, it's a rural development form 3560-8. It's a summary of the tenant's recertification. In that form, the tenants are indicated at the income level of very low income, which is the highest priority by federal statute for receiving rental assistance. And yet on the second page of that summary certification, they don't follow the process flow correctly. If the tenant receives rental assistance, enter line 28 on line 31 below. That box is checked, but then line 28 is not entered on the line below. The reason for that does involve Keystone, or apparently involves the presence or involvement of Keystone Place. But at no point in time were the tenants.
Well, I didn't ask you all this yet.
Okay,
I just asked you how much you believe she owes.
Explain.
So
Yeah,
you believe $212 from June?
224, Your Honor.
All right, from June to
Arguably the present, if there's not been a new certification, but it seems that there was a rental adjustment. There was nothing in the records I received, but that was elicited at the last hearing that there was a gross rent change in December or something like that. So that would change the rental rate. And then there was this attempt in December starting in January.
All right, I'm just trying to figure out how far apart we are. So 212 from 224 from June to when?
At least December.
All right, so that's 6 months. 224 times 6 is 1,344. 224 June to December. 6 months equals 1,344. All right, then if we go forward from December to January, February, and March, what do you contend the rent is for those periods of time?
Based on representations from my client, $212. Absent any change in documentation, it would still be $224.
All right, so 224. All right, 224 times 3 is 672.
And that doesn't account for any payments that have been made.
$2,016. So do you contend payments were made?
Keystone Place paid $1,083 a month for 6 months.
After June?
Yes.
Starting in June.
I can break Your Honor, just looking at the ledger, I can give you the payments that are reflected in the ledger, so they're not contested.
All right.
All right.
Payments were what?
So payments, so here I'll go through this. Payments since June 1st are $1,083 on June 10th, $975 on June 10th, $34 on July 1st, and then also on July 1st, $1,083. And then there are 4 other payments of $1,083 that were made on August 1st, September 1st, October 6th, and November 10th.
All right, so during the period defendant contains the rent is $212. Someone other than the defendant is paying $1,083, give or take, all the way through November.
Correct.
All right, so 10/6, 1053. 1053 times 1, 2, 3, 4, 5, 6. $6,318 plus 975 plus 34, 1009.
So, Your Honor.
Just a minute. Just a minute.
Sorry.
All right, 7,327. All right, so that would pay the rent through November. So what appears to be at issue from Enchanted Glen's position is the rent is December, January, February, and March, I think is what we calculated last time.
Yes, I can give you that total.
All right.
That is $4,372 based
I thought
on,
we had 4,362.
there's been a $10 late fee that must have been in there
All
that
right.
maybe wasn't it should have been last week too, but it hits on the 11th. We should have been here, but so yeah, and that's at 1,083 for December, January, February, and March with $10 late fees. The account is, I mean, just to clarify, the account is based on the ledger that I just sent Ms. Bauer as well. The updated there, it's current through November. So there's a zero balance as of November 10th. And then the balance forward for those months that you've identified is $4,372 and through March 11th or through today.
All right, so the fundamental disagreement is defendant claims rent is $224 and plaintiff claims the rent is $1,083. And the rub happened, according to Ms. Cleveland, they thought Keystone was going to pay the rent for 18 months and Keystone stopped paying the rent as of December 1st.
The other option or the other part of this though, Judge, is that the defendants would have accepted the rental assistance in the permanent subsidized housing had that been properly communicated. So the idea of the rapid rehousing program is to get people established into stable housing. These tenants were eligible for rental assistance and should have been put on that program from the jump.
All right, so who failed to do that?
At this point, I would say that falls on the property manager. If I may share my screen, I'd like to demonstrate where I'm getting this from. I'm not just making this up, I guess.
All right, go ahead.
I have redacted the personal identifying information from these documents, Your Honor. So this document here is the form 3560-8 that I referenced. It is, can you see my cursor or no?
Yes.
Okay, so it is indicated to be the initial certification for move-in. You see the tenants are listed as household members. The calculations here, what I was referencing, if the tenant receives rental assistance, enter line 28 on line 31 below. You see this box is checked. And I have to move you guys out of the way here. I apologize, this does have my notes on it, but if tenant receives rental assistance, enter line 28 on line 31 below. So line 28 here is 326. Line 31, you see that number is not entered here. 326 is not entered. There's a deduction for the utility allowance, which gets us to the 1,083. Where this matters is because up here, the current eligibility income level is V, and V stands for very low income. And that is the first priority under the rural development regulations for rental assistance. These properties have a rental assistance tenant selection plan. And Keystone shouldn't be paying $1,083 when these tenants are eligible for rent and able to pay $224. And that rent, that assistance.
Who made that calculation? Is that your handwriting?
That's what I say. I apologize that I wrote on here. That's me.
All right, but so where do we get that figure?
So if you follow how the form is supposed to be filled out, if tenant receives rental assistance, they're very low income, they're eligible for rental assistance. Enter line 28 on line 31 below. Line 28 is right here. and line 28 is 326. So the number that should have gone on this line is 326. But instead, the number that went on this line is 1,185, which gets us to the final NTC, that's net tenant contribution, also known as tenant rent, essentially, the tenant portion of rent. So here, they've determined that the tenant rent is 1,083. That matches what we see on the ledger. The problem is, this form is filled out wrong. It
All right,
1,100.
well, at this point, you're testifying as a expert or guess as to what should have been done. I'm not saying you're wrong, but and I'm sorry, Miss Shaw, I called you Miss Snow. What's your response to their contention that the form, would you scroll back up a little bit, Meg?
Yep.
Wasn't down a little more. A little more, all right, little right there. All right, we got part 6 and part 7 and part 8. So according to this, rent is $1,083, which is what was charged, and Keystone was paying it. Their contention is that this wasn't calculated correctly. What's your response to Ms. Bauer's representations that she just made regarding how it should have been done?
Your Honor, to begin with, Keystone will not help people that get rental assistance. They pay the whole amount of rent. So if I was to have given them rental assistance, Keystone will not pay it.
Correct.
So at the time.
So if someone has a subsidized rental rate, Keystone won't pay it because there's an assumption that they're already receiving enough assistance, and Keystone pays rent for people that are not subsidized. Is that correct?
Correct. And
Okay.
once I get this information, I send their packet to our compliance department and corporate. They fill this out. They send this, they put this in the computer, and I print it out. I don't know what their rent is until after the fact, until I get it on my end. And that's what Keystone, that's why their rent was $1,083. In January.
And Keystone paid that for months.
Yes.
And then at some point, Keystone stopped paying the rent?
They stopped paying the rent. I do believe, if I remember correctly, was been December 1st. Was their
right.
November 1st was the last rental payment from Keystone.
All right. So once that happened, should the defendants have had a recertification?
Yes, they should have. And they started to come over and they filled out the application portion of it, signed all the application part of it, but they never came over and finalized it by signing their lease, their current lease that they would have had after signing the application. In
All
January.
right, there was some discussion of that. Now,
Yes.
And Judge,
okay.
I don't have any of that.
I'm not allowed to send that completed because I was talking to my boss and they said, do not send anything that is not completed.
Okay. So they don't get to double dip. They don't get a subsidy and then Keystone pays that subsidized rent. It's either all or nothing. So Keystone, and Miss Cleveland's representation is they said they were going to pay for 18 months, but at some point they stopped paying. So Mr. Popovich is correct. The rent is paid through November. So we're talking about December, January, February, and March. Ms. Bauer calculated at $224 per month. Your testimony is different. The bigger question is whether they should have been recertified, not whether the rent should have been $224 per month. because it was 1,083 through November.
Except, Judge, I don't have anything. I have documents between, I have Manager Kim Shaw, and I have a representative from Keystone signing documents that the tenants are being placed in this program, but I don't have anything showing that the tenants have consented to this or were given an opportunity to get on the rental assistance, the permanent rental assistance program that they were eligible for and trying to get into.
Well, that's what we're trying to determine.
I mean, back in June. I mean, not
But
getting.
what do they care? They got $1,083 worth of rent, and they didn't lose a penny. Keystone may have been out 1,083 if rent should have been something different. But if their rent, they're better off with, if it was subsidized, they would have had to pay that rent from June, July, August, September, and October, and November, and they paid zero.
Yeah,
Keystone
and
paid it all.
Judge, there's two reasons. One is dignity. Like, a lot of people think that subsidized tenants ride and abuse the system, but actually a lot of my clients prefer to have the dignity of paying their own rent. Second of all, and I'm sorry, Judge, second, Keystone is a temporary program intended to transition people into stable housing. The golden goose is to get rental assistance. That is the goal that tenants have when they move into subsidized housing. So they do care, because if they were on that program, we wouldn't have had this sudden pulling out from under them of the sheet, or pull it rug. I don't know where sheet came from.
Well, I don't think they have any damages, but dignity is hard to put a dollar figure on, and it wasn't done. And I don't know why, but we now know that the Keystone subsidy was expired or removed or canceled. The defendant's contention is they came in and thought they had recertified. Ms. Shaw's contention is they did not. So we need to figure out now right now, according to plaintiff, they did not complete the recertification process. Keystone stopped paying their rent, and they contend that they owe, why don't you give me my screen back? We got this random stuff scrolling on the screen. $4,772. If you're, now, I don't have a witness to tell me what the calculation should be. You calculated it, but you're the attorney. So even if I use your figure,
I could do this through an adverse witness from the property management company.
well, I'm not sure she could answer it that way, but
I don't think it's fair to spring these exhibits on Attorney Popovich without him having a chance to discuss and see them. I've got a couple of other exhibits.
well, there are exhibits that are in his possession also, but what I'm trying to avoid is a 2-day trial on this. I have to be in Kalamazoo at noon, and I'm not going to make it. I was hopeful you guys could get somewhere, and you're not anywhere. So we're fighting about the difference of about $2,000. The farther we get behind, the less likely is the defendant's going to be able to pay the entire rent. Keystone's no longer paying the subsidy. Even if we do it at a subsidized rate, we'll be into April. It's going to be about $3,000, give or take.
At the subsidized rate, Judge?
So
it would be about 800.
Well, I guess about $800. 224. That's your calculation. I don't know what it really is.
Right. You said at the subsidized rate. So I just
at that rate. So
It's 11/20. It goes through April. At the 224 or whatever that rate was, it'd be 5 months. Remember, we're talking December, January, February, March, and then April. We're not into April yet, but for purposes of any
Yes.
continuation, it's about 1120
Sure.
plus the court costs and the other amounts.
Yes. Well, if you'll agree to that, we can use that figure right now. But I don't know that you're in a.
Well, Your Honor, may I have a chance just, and I don't want to waste your time, and I know you have to travel. I don't want to.
I'm already not gonna make it, so go
I
ahead.
appreciate the way you're handling this, and I've been sitting here letting Ms. Bauer testify and argue and commingled, and that's fine. I respect her, and I think she has as good a handle on these forms from an adversarial standpoint and an advocacy standpoint as anybody. But I agree with Your Honor's take on, dignity aside and all these other things. These folks haven't been damaged. They had 1,083 paid for them from June till December or till November. And the issue of whether that was more than what should have been charged is between Keystone and the complex, if there's any issue there between them. And I don't know that there is. I have no knowledge as to that. And then, quite frankly, my guess would be if really we wanted to unwind the ball of yarn, 1,083 goes back to Keystone, and then 224 is charged to Miss Cleveland, who's then another 6 months behind in rent added to the December through April. So that doesn't put her.
Yeah, they're worse off if we went in that direction.
Right. They're worse off. Plus, Keystone's not even a party to this. And I don't know how we articulate or even handle the lack of presence as to there's no claim for the return of the 1,083 or any claim from Keystone against the Miss Cleveland and Mr. Roush for the overpayment or against the complex. However, Keystone may preface that type of issue. If here's one concern. I don't know that these folks can even, and I'm not saying this disrespectfully, but I think that 224 for now 5 months plus the court costs, that's a significant amount of money, and they'd still probably likely need some assistance to come up with all of that. And there's third-party agencies that may help them. I'm not adverse. The
third-party agencies won't help them if it's a subsidized amount.
So
if they're not going to be eligible for Keystone or DHS or the others, that's either money they're going to have to pay. So if you agree to that number, we can use that. But I'm not sure at this point you wish to do that.
I'm long-winded, and I apologize because I'm getting to that issue. I wasn't aware. I think some other counties, the DHS might help if there's subsidies, but I defer to you and Ms. Bauer in that regard as to this area. But I'm not adverse to having a private conversation with Ms. Shaw, talking this through and making a decision as to the 224 to avoid sort of this length and the cost associated with Ms. Bauer's dissection of these forms and sort of the argument as to, is the application indicative of a recertification, or because no lease was signed, it doesn't process.
I'm going to open 2 breakout rooms. I'm going to let you talk with your manager. I'll let Meg talk with.
May I
go ahead?
One last thought, just because it's pressing, and something for Your Honor to consider, plus Ms. Bauer. We don't have a completed recertification currently. So we from policy standards, whether Ms. Bauer believes that's correct or she wants to make accusations as to mishandling or anything else that she's likely to do, and it's kind of insinuated, we don't have a completed recertification form and lease. So if we agreed to those figures just for the purposes of this 10-day order to get possession and payment and to figure out the possession action as currently prefaced with the court, we have this issue starting in May as to what or maybe April if it was today, because we're not.
It would be April.
It's April. What's the rent? And we're going to still have it at 1,083. This is why I enjoy conversations off the record between hearings with Ms. Bauer, because we try to work a global resolution that avoids those sort of secular arguments that continue to kind of reform every cycle. So I'll talk to Ms. Shaw and I'll get some feedback from her and we'll come back. But I wanted to put that out there that, equitably, it's not within the court's power to force the recertification at this point based on the preface of the pleadings in front of it. But if there was any tolerance for this amount just to be done with this, I won't say anything crass, but these arguments as to the amount and what amount it is and whether or not it's irrelevant or a relevant point, we've got to address that as well, both with Ms. Shaw, but then also with these tenants.
All right. I'll put you, it's not your fault. I'm missing a luncheon program and the afternoon program, but we'll get there when we get there. They're gonna start without me. All right,
While you're putting those rooms together, I just want to point out that this speaks exactly to the bias that my clients often face, which is that this whole conversation, the presumption has been that my clients can't afford $1,000 to keep their housing, and that they will be requiring public assistance, and that's just not always the case. Also, the damages that my clients are experiencing are this massive risk of homelessness that so it's more complicated. It's always
more complicated, but in point of fact, no rent has been paid since December. Enchanted Glen has a waiting list of people that are homeless that would like to rent this apartment.
These guys again.
So there are always multiple sides to every story. I don't know if we're going to accomplish much here, but I'm willing to give it a shot. I'll get there about 3 o'clock. Let's see what we got. Add a room. All right, assign room 1.
Gary, before you go in there, I still don't know what my clients actually would need to provide your client to complete this recertification. I've looked at the correspondence I've received, but there's nothing in writing about what they still need to do. So
Kim, you're sworn in. Thanks, Meg. Kim, you're sworn in. Why don't you just articulate without giving more than you're comfortable, but share with Meg what these folks would need to do to complete the recertification.
They would have to reapply because their paperwork is more than 90 days and compliance department won't take anything over 90 days. So they would have to refill out their application and give me all their income, all their banking information from both parties, him and her.
Okay. All right. Fair enough. Thank you.
Yep.
Don't understand what was missing before then, but you and I can talk about that later, Jerry.
Well, and I guess, Meg, remember, they didn't sign the lease. There's policies, and I understand your take, and I understand your equitable arguments that you're making, and you're a heck of an advocate for these folks, or all of them that come through. But if they don't sign the lease and they don't complete the process pursuant to the policies, listen, I'm not here evicting every tenant in Enchanted Glen. I'm here evicting certain ones that don't comply with the process. And so if they didn't sign the lease, we're not picking.
I wasn't trying to reopen the debate. I was just trying to let you know the things that I was looking for while you're talking to your client.
All right. Okay, Mr. Popovitz, I'll put you in there with Ms. Shaw.
Thank you.
And then room 2, I will assign Meg Bauer and Mary Cleveland. Miss Cleveland, hit the button that says join.
Judge, is Miss Cleveland still on your screen?
Yeah, she's frozen. I'm gonna let this go till about noon. I'm long behind this 12 o'clock lunch meeting. My job is paramount to what other things I may have going on. So that people pay me for. Michelle, I've got your 2 general civil cases. And Elaine, I've got everything but this last case. We might be here till dark. Well, here's your two general civils and Elaine's landlord tenants. I got one case left.
Very good.
And that's a really fun one.
What is this one for, Judge?
That goes with the Beachy landlord tenant case, which I think they already took.
Okay.
Uh-huh. All right, the live stream is on and the record is still on. We've got 2 seconds. They should be joining us. All right, Ms. Cleveland is back. McBauer is back, and the plaintiff and manager are back. Mr. Popovich, you had an opportunity to talk to your manager, Ms. Shaw. What's the plaintiff's position?
Your Honor, we've talked, I have a amount of respect for Ms. Bauer, but I have a admitted lack of, I think, patience in some respects for these arguments when a non-payment turns into a complete breakdown or analysis of the recertification. And I've made my peace with that in the earlier comments that we're not evicting every person. So there's not a failure in the process, but some people haven't complied, and then there's consequences or ramifications. That being said, I had a wonderful conversation with Ms. Shaw. She understands. Her and I both work for higher ups in management at TM, but we're both comfortable putting this on the record. I would agree to resolve this with agreeing to the 224 rent due from December, January, February, March, and April. And I'd give them until the last day of April to pay that amount and have a full recertification process completed and accepted by TM or by Enchanted Glen. And I do that because I find that tenants who put themselves in these situations can benefit from not only the advocacy of legal services, but the assistance of legal services to help with the recertification process. Ms. Shaw, whether Ms. Bauer likes to like the answer or not, says that everything needs to be resubmitted because it's 90 days past due. We do answer to these subsidies. We have certain things that have to be done in accordance with the timelines and the current the documentation has to be current. So where we would want is the last day of the month is April 30th. It's a Thursday. By then they've paid all of this rent at $224 per month plus the court costs, and they fully recertified, and we can move on. And I will deal with the internal communications to TM as to why they're only getting $224 a month versus $1,083 a month as to these months in question. There cannot be today or any day in this court case, based on the filings and the pleadings as currently situated, a determination of the recertified rent amount. It may not be $224 as Ms. Bauer has calculated because the information has to be resubmitted. But this is her opportunity, and she can certainly utilize my openness to communication throughout the recertification process to address any concerns she has with TM's corporate compliance as to the calculations, or help her clients to make sure that current documentation and appropriate documentation is presented so they get the most subsidy that they can possibly get. It'd be a global resolution, and one way or the other. And if they're not able to comply and they don't like the rent after that, everybody's still bound by leases and Michigan law. But this is an opportunity to not spend any more time in court testifying over rental subsidies, assistance, what should have been done, what shouldn't have. This is a non-payment case, and conceding the rent for those months and giving them the buffer of April to complete everything, moving forward with, by then, a well-informed decision as to what May's rent would be, seems like an appropriate opportunity, and it does save somebody from becoming homeless without having their day in court. I apologize for going on and for any tone that I may have taken, but this is the opportunity that I think presents itself based on the openness of these discussions and what we're willing to do going forward.
All right, Ms. Bauer, what's your position regarding that?
I think that that's generally a very fair and reasonable offer. I did, as we were being pulled in here, send a different offer to Attorney Popovich. He may not have had a chance to see it or not, and he may not agree with it. I think it's a fair and reasonable offer if his client is willing to make the adjustment to the final account to reflect those numbers, and so that if there's no going backwards and undoing, that it's not just for purposes of possession. I think it's a very fair offer.
All right. Now, then they're going to have to get recertified during April and late March. But it is very generous because it goes all through the month of April. So I find 5 times 224 is 1,120. We previously determined that court costs are $313.45. That leaves us with 1,433.45 due by April 30th.
But of course, Judge, I don't know. I guess I had sort of put a condition on that. I don't know if about the account actually being reflected, changed to reflect.
Well, I don't. What's your response to that?
Can that be explained to me? What are we looking at?
No, I don't need it. This is my ruling. I'm gonna accept your generous offer. If it comes to a money damage hearing and they're gonna claim that 1,083 is due and owing, in the unlikely event, we'll determine it at that time.
Well,
Ms.
I mean,
Cleveland, you've
there is
got
one-
until the end of April to pay $1,120 in rent and $313.45 in court costs, which is $1,433.45. You also need to go in and complete the recertification process. I don't know what your rent would be. There was an allegation that Mr. Roche had some income, and he needs to be here. He's sleepwalking through this. You're here, your lawyer's here. He's not here. He's a party to this, and his income is relevant. Now, he may have some illness and some other things I don't know about, but he does have Social Security, perhaps other income, a pension or something that will need to be calculated into this. But I find that you have 10 days to appeal this, Mr. Popovich, which would still be the March 30th date. The rent due date is April 30, 2026. The rent is $1,120 and the court costs are $313.45. So the defendant now has 40 days, March and April, to pay the rent and get recertified or move out. You may decide you want to use that $1,400 to move into another place.
That's why I was asking the account question, Judge.
Well, they're not suing for money damage.
They did sue for money damages, Judge.
But this is not a money damage hearing. This is a possession hearing. So if they pay the rent, they get to stay. If they move and we have a hearing regarding money damages, in that unlikely event, we'll determine it at that time. So essentially, Ms. Cleveland, you got what you asked for. Ms. Bauer has vigorously argued that your rent should be reduced to $224 once the subsidy ran out, and the plaintiff has agreed to that. The court costs will be the same no matter what. Now, my belief is if this is a subsidized rent, that you're not going to be able to get assistance from Neighborhood Inc. or Keystone. You can request it. You'll get a copy of this judgment, but I don't think if it's subsidized, they're going to additionally pay it. But I may be wrong on that, and different agencies may have different standards. I know Neighborhood Inc. doesn't pay for subsidized rents. So I don't know if you've got $1,433 that will pay your rent. That would be great. May 1st, the rent is going to be something different. You'll have to sign a lease. You'll have to agree after the recertification process what your rent is. If you're eligible for a subsidy or if you're not, as of May 1st, it will be different. If you pay this, then May 1st will start fresh. If you don't, you're subject to being evicted on or after April 30th. You can certainly discuss this further with Ms. Bauer. You and Mr. Roche are going to need to get in with all of your documentation and start the process to be certified to stay at Enchanted Glen under a subsidized rent. And your lawyers both spoke to this. If you get evicted, it's going to make it difficult for you to get in anywhere else. But the plaintiff has folded their tent and giving you what you asked for. But at some point, you got to pay some rent. No rent has been paid in the last 4 months, and the 5th month is coming up. So hopefully between you and Mr. Roche and your sources of income, you can pay that. But it's incumbent upon you to get with management and get a recertification. Mr. Popovich, I'd ask you to email me a judgment in that amount, $1,120 rent through April 30th, court costs of $313.45 for total possession only judgment of $1,433.45. The appeal date is still March 20th.
And I will put the payment due date by April, the last day of the month of April. And I don't know that the further order section has to articulate any specifics as to the recertification, but I think that's well established that this isn't a concession moving forward. It's an economic concession to solve this problem. And certainly they behoove themselves to complete the recertification process. They don't like to pay me to be involved in the recertification process, and I understand that, but I am offering my very affordable and economic assistance in the sense that if Ms. Bauer likes to reach out to me or needs to reach out to me to assist these people, I will act as a go-between and not become a problem for either my client or them in the sense of helping with the relay of information. I would like to see a global resolution here. And I appreciate your Honor's take and handling of the matter. And I appreciate Ms. Bauer's assistance and advocacy. And I remain open to communications to help her if she has any questions as she helps these folks through the recertification process.
Now, Miss Cleveland, you've already started moving your stuff out of there. If you just decide with Mr. Roche, you're just going to move before April 30th. If you just decide you're going to move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving out. I'm not determining how much money is due at this point. So if there is a hearing regarding money damages, that'll be at a different time and place. All I'm telling you is if you pay this amount, $224 for 5 months plus court costs, you get to stay there. Rent will be calculated at a different amount for May. All right. I appreciate everybody's effort in this. Meg, do you want to talk for? Well, I'm going to shut everything down.
Yeah,
So
I'll call her.
if you need to call your lawyer, you can call her.
We'll discuss what is in your strategically the best interest in light of this the judge's decision.
All right. Thank you all.
Thank you, Your Honor. Take care. Thank you, Ken. Take care, Meg.
Thank you.
Thank you, Ms. Cleveland.
Thank you.
To me.
I know. Say something to her. Hi. Yeah, it's her turn this time.
Okay. All right. Go
yes.
ahead. Are you finished yet? Jeez.
Not yet. We are.
Okay. All right. I'll wait.
We're requesting permission to practice in your court under MCR 8.210.
No.
8.120 under the permission of Davis Center Crozet. Sorry.
Thank God your school can play basketball, but go ahead.
I know, because clearly this isn't it. I'm joking.
You're requesting permission to practice pursuant to that court rule under the supervision of Mr. Santa Croce.
Yes.
Is that what you were trying to get it out?
Yes, that's what I said.
Okay, all right, fine. Wow, she's got an attitude. Where's she from?
No. I
know. Permission to practice is granted. Where are you from?
I'm from California.
Oh, that explains it. All right. Where'd you go to undergrad?
USC.
That also explains it. Okay.
Oh my God.
Why'd you let her go first?
I'm actually
Young
going
lady from
second.
Maryland?
You said, why did you let me go first?
Oh, well, because it's her turn. We gotta share the stage.
Right.
Where'd you go to school in Maryland?
I went to Goucher College. And my
Say
brothers
again?
I went to Goucher College and my brothers went to UMD.
All right. I like her better. Anyway.
It's fine. I almost like her better too.
All right, what are we doing on this case?
So, Your Honor, we received an appearance from the student attorneys as well as from Attorney Sandra Croce. So they did file an answer. Well, I just asked for a more detailed answer with affirmative defenses. And so I believe that today, since they filed their appearance late on this case, I believe that maybe an adjournment would be appropriate here so that we could get a proper answer with affirmative defenses, as well as we can commence communications, perhaps for settlement negotiations or a potential for resolution.
The dates Counsel, would you agree with that?
I would say that, yeah, we are open to an adjournment. We think that would be appropriate. But we do believe that we provided a complete answer to the complaint. It's our understanding that affirmative defenses are not required for a sufficient answer, but we would be open to adjournment and maybe getting some discovery.
She figured out like a legal thing she learned in class. No, go ahead.
I'm trying to do my job. Yeah, but we would be open to negotiations as well. But I think.
All right, folks, I have either next week. I do not have the 3rd. My next time after that is the 10th. So.
Your Honor, I will be out of town next week. However, the 10th, I could be available for the 10th.
All right. Will that work for? Then we'll judge. She's like, I'm here, Judge. I'll adjourn it to April 10th, 2026.
You're
2 p.m.
Can we get permission for limited discovery?
Wow.
It's a conduct.
And you understand the way that I operate is that I expect the parties to cooperate regarding discovery. I do not allow depositions and the like. If there are certain things that can't be answered, I'll certainly do that or entertain it on the 10th if certain information isn't provided, but I'm not going to order that. I expect the parties to cooperate with it.
Thank you, Judge. I just want to make one clarification for the record. The reason why I respectfully asked for some affirmative defense is because I don't know if the court recalls, but defendant appeared at the last hearing with the court had indicated that they were in receipt of several documents filed by the defendant, along with a flash drive containing video. And so the court had requested or required the defendant to serve that on the plaintiffs. And so we did receive all of that. However, due to the, I believe just the quantity of the documents, along with, I want to say like almost 100 videos and photos that were sent on the flash drive without any context, I believe that an affirmative defenses would be appropriate here to describe or explain or support what position the defendants are taking or the defendant is taking.
And the context upon those documents. And counsel's right. I don't know. Did you guys receive the documents that your client had filed?
Yes, we did receive the documents, and we are working with our clients to better understand them. We do think that context, could be necessary.
All right. I think whether we call them affirmative defenses or not, it's really clarification and context to the documents that have been filed is really what we're looking at. I think all of us.
And we can provide.
All right, especially the one from Maryland. All the rest of you, whatever. All right. Take care, guys.
Thank you. Bye.
Thank you.
This tenant did not check in. Haverhill on Clark versus Talib Mahan.
Good afternoon, Your Honor. Rania Haddad for the plaintiff.
I do not have Mahan checked in.
The nature of the cases so far, Your Honor, I believe that the defendant's children have appeared, but they don't really name themselves. So it could be the individual that is on the iPhone, but I could be wrong.
Pardon? my staff indicates they normally do name themselves. So, and when I get out here, certainly they are named, but Talib Mahan. It worries me a little bit because I know Dad I think had some health issues. Mom was there and then has had daughter twice, or has had daughter in the case, and then their son appeared, but they're always here.
Correct. And I do have an update, Your Honor, on the status of
Yeah.
the Hawk. So my client indicated yesterday that they did send over the documentation requested by Hawk, and the conclusion of what Hawk is going to cover is that they will cover $1,783 of the $2,346.32 total. However, the caveat is that the defendants have to pay $563.32 before Hawk submits or tenders payment to the plaintiff. So, we adjourned this 3 times.
Yeah.
I hate to have this all go. I don't know if there's someone that can reach out to the defendant.
What is their monthly rental rate?
I believe it is. Let's take a look.
After their Section 8 pays.
Let's take a look. I had that pulled up, and of course, now that you're asking for it, it's become lost to me. Let's see if I can. Take a look. Okay, so it looks like the monthly rent is $375.
Okay, so they'd be around the 9. If we kick this out to the 10th, let Hawk come through and pay. They're at a point of about 900. They'd be 900 short.
Correct.
I just would hate to take the judgment. I'm just concerned that they're not here. I'll be honest.
I do agree. I'm just a little concerned because we just keep taking on a little, more. I know we adjourn this in the best interest of the defendants, considering the defendant, considering the nature of the situation. And I mean, I'm glad that Hawk is going to cover the majority of it. Upon the information that was given to me, Hawk indicated that the defendants were supposed to pay their portion yesterday. I don't believe that has happened. So
that may be why they're not here then. So we get a checklist, or at least they're starting a process. They're not on our form, but I'm wondering if they did pay it, presume that Hawk's gonna pay the rest and then didn't show up. But I don't know if you had communication with your client regarding that.
So my client did indicate to me yesterday after hours that that was the most recent updated information that was provided to them by a Hawk representative. And they have not, and they're pretty good about updating me, which I asked them to do yesterday if the situation changes and that if the defendant remit the payment. That has not changed, Judge. So I'm not really sure.
Oh, you know what we'll do? If they're gonna pay it, here's what I'll do. I'm gonna do it this way, I think, because I want the figure locked in rather than kick it over into April. I'm gonna grant a judgment for possession, finding no tribal issue. What is the total amount due right now?
The rent to retain is $2,176.32. Attorney fees and costs of $170 for a total redemptive amount of $2,346.32. We can do the judgment, the writ date to reflect that there's 3/31 instead of 3/30. And then no.
Yes, what I will do is I'll do a writ date of March 31st, 2026. And given the circumstances of this case, I'm just going to indicate no writ without a hearing. That way, if there's some miscommunication, something, we can try to get that corrected.
Okay, thank you, Judge. And so I will submit a default judgment with, would you like me to put in the further orders, no writ without a hearing?
Yes, please.
Okay. Thank you, Judge.
All right, thank you. Is that all she had? All right, have a great weekend.
You do the same.
Six Trails versus Eric Houston.
Good afternoon, Your Honor. Sidney Katz on behalf of plaintiffs.
They're not here. All right. Houston, they're not here. If you'd like to take a default, raise your right hand. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Go ahead, sir.
Your Honor, this is a non-payment rent possession case. This is a second hearing at this time requesting a default judgment. Defendants have failed to appear to the best of my knowledge. The defendant is not in the military, minor, unable to stand trial. And to the best of my knowledge, the property is being kept habitably. Currently, there's a balance due, including costs totaling $1,994. That's $1,994. Requesting a default judgment in that amount with writ to be issued after March 30th.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested with writ to issue in 10 days.
Thank you, Your Honor.
Willow Ridge Apartments versus Taisha Johnson.
Good afternoon again, Your Honor. Sidney Katz on behalf of plaintiff.
Miss Johnson, she's in Zoom.
Yes.
Oh, there she is. Ms. Johnson, if you can unmute.
Okay. I'm here
Hello?
now. Yes, sir.
Okay. All right. What is the current balance?
Your Honor, the current balance is $4,347.
Okay. All right, ma'am, how are you going to get this paid? I mean, we're coming through February and March and we haven't, balance isn't coming down.
Yeah, we might as well. After
Ma'am, you're breaking up.
last time I
Carol.
came in, I just had started working, so I haven't even received 34. Oh, I'm sorry, well, judgment because the other program, I've been caught in the programs, and the last one, y'all just.
Ma'am, are you driving?
Yes. No, sir.
She is. You're not.
No, I'm not driving.
Okay. Start again.
No, I'm sitting in the back seat. I'm not driving.
Okay.
She gave me the MOP program, MAP. They don't have any funds. So what I said, moving forward, I will have to, because I have no other form. I just started working, so trying to catch myself up is not gonna happen. So I did everything that you asked me to do, and nothing has fell through. Hawk said I make too much. And then last week when I called MAP, I got on their website, it says they has no funds, so they wouldn't even let me fill out an application. I emailed it, I took a screenshot, and I emailed it to I think Amy to let her know that, yes, I have tried and everything like that. So I know you cannot live nowhere for free. I'm quite understand that. So like I said, I just, wherever, how long I got to get out to put my stuff somewhere, then I understand, but no one's helping me. I can't get that balance down working.
Here's what I'm going to do. And I know you've given it your best shot. I'm going to grant a judgment for possession, finding no tribal issue after a hearing for the total amount of the $43.47. That's just a possessory judgment. The writ would normally be the 30th. I'm going to have the writ April 3rd, 2026. Well, over the objection of plaintiff, but I'm going to give her.
You did it again, Your Honor. You didn't
I
even
know
give me
I
the
did.
opportunity. This is killing me.
I don't understand.
Objection, Your Honor. How's that?
I don't understand. I'm
Overruled.
sorry, you guys. I don't even understand what y'all saying. I'm sorry.
What just happened? Okay, here's what I
Yes,
did,
ma'am.
Johnson.
Okay.
What I did is I issued a judgment basically to lock it in. I've given you I think you exhausted everything in terms of trying to find the funds. And you need time to get yourself someplace and get your stuff someplace. So I've issued a judgment giving you then to April 3rd to try to get your things moved and get yourself situated as best you can. That's
Okay.
the bottom line of what I've done.
Okay, I got it. And I have another question. This is so with this put an eviction on my name, I never had one, so I know it's gonna, if I do, it's gonna make it hard for me to get somewhere else. And when I moved into this apartment, I didn't even have a check stub. I just had a exception
No, I know.
letter from a job. I didn't have a background check. Nothing got ran. I didn't do. I thought I got in by the grace of God because I didn't show proof of no renter history. I didn't even have a check stub to even. I
No,
just had an accepting letter, and that's what's spooking me out is eviction.
Right. No, I understand, Ms. Johnson. You had explained that to me at the first hearing. It's not a whole lot I can do about that. Maybe if you arrange with the landlord, once you get yourself out, a payment plan, they could set aside the judgment so it doesn't appear that way.
Okay.
But that's one way of trying to work it out. Okay.
Okay. Yep, that's fine. I appreciate it.
All right, Ms. Johnson. You take care of yourself.
I will. Thank you.
Thank you.
Bye-bye.
I think that's
Your
it for you, Mr. Katz.
Yep. Have a good weekend.
Okay.
You do the same, sir.
How can I hang up?
All right. Now, everything else is,
The bear and the side will try, you want to go grab some?
well, has everybody been talked to? I got all these people staring at me. What? They didn't talk to you? Were you nice or no? Okay. I am nice. They haven't gotten around to you. Is that the deal? Is that? Oh, they just didn't get to you yet? You what?
That's Miss Dewat, yes. She went to 1482 in Eric. We haven't called her names yet. She's a peninsula place.
She went to the wrong court?
Yeah, she went to 1482 for this afternoon.
Why'd you do that?
Well,
It's okay. It's all right. We got you here. You're good. Okay. Yeah, we might want to, well, just see if they're ready on any. Otherwise. Has everybody else been talked to by them? Okay, so they might be ready on some of them then. Is everybody here in college?
No.
No? Okay, so you're not, but everybody else is. You're not? Would you guys get kicked out? No, I'm kidding. Don't.
said he'll be right in to start placing consent. Mr. Visconti is going to come right in.
Oh, okay, all right. See, in the room.
Yeah, she gave us.
Okay. What's Conti doing? I think I got all day. No, to make him come rushing if I just start. What? No.
Ask a question.
Sure.
Landlord tenant thing, should I go back out there and have them sign in? Or someone looked at it and I walked in. Sure.
So your case is set at 1?
Correct.
All right, we are on to 12 o'clock. You don't have to, we will make sure that you're checked in. What's your name?
Oh, Dave Fun.
Got it.
I know.
Why do all these people look like they're going to the gallows? Everybody relax. You guys are tensing me up. Here we go. Santi, how are you, sir? Okay. Okay.
How are you?
I'm okay. Maybe, let's do this. Why don't we find out what cases he's ready on rather than just calling them in order?
Sounds good.
And, anything goes to you?
But if he tells me the name, I can pull the file and just in case.
Let me just get him in case number order and go through them with you, okay?
Okay. I see she's there. Which cases?
Good news is we do have a lot of them ready to go.
Okay.
$663. 699. So, oh, 680. 722. 723. 707.
707.
Yep, 722, 723, and 707.
I'll need you get certain.
Seven. 691. 98. Yep. 685.
Roll here.
And
Court does call the case of Covington Apartments versus True Win.
Robert Piscani, P6175. Blank.
Hello, what's your name?
Choking.
All right. Where are we on this case?
Your Honor, we have a proposed consent judgment for its consideration. Rent retained in this case is $2,220. Court costs are $173.36 for a total redemptive amount of $2,092.36. The parties have agreed that amount will be payable on April 3rd, and that defendant will pay her April accrued charges by April 17th or an order of eviction issue. We did that extension. The loose, including the April rent, is consideration of that extension. For a second set of court costs for the month of April. The payment arrangement is set forth in paragraph 10, and it advises rights pursuant to MCR 4.201. She dates
All right. Ma'am, is all of that correct? Do you have any questions regarding any of this? All right. And you did understand your 3-day right to rescind this or to ask the court to look at it again? Okay. Grant judgment to the plaintiff, that is by consent. Court has signed this. Now sign the judgment, and thank you very much for working it out. If you want a copy of the judgment, you can pick it up at the front counter. All right, thank you.
Good luck.
Peninsula Place versus DeQuan Winner.
Your Honor, what are the last three of that case number?
Last three is 698. He's in Zoom. His iPhone.
Yeah.
All right. Winner, if you can unmute, please.
Hi, how are you?
All right.
Hello? Hello?
Yes. Hello. Can you hear me?
Yes.
All right. Very good. Where are we on this?
Robert Visconti, plaintiff, Your Honor, we have a consent judgment in this matter.
Okay.
Believe that has been e-filed.
Well, we don't have e-filing.
I'm sorry.
Emailed, if anything, was if.
Mr. Gwinner,
Yes.
did you agree to a judgment in this case?
Yep, what's the judgment?
Probably not.
Pass on this one.
Yeah, Mr. Winner, I
I'm
need you
the
to
one
hold
that you
tight.
talked to last week. I was in the hospital from the stroke and I had a heart
Yeah.
assistant.
Right. Okay, I'm gonna pass your case for a minute and then we'll call it back up momentarily, okay?
Do you know how long I gotta go to physical therapy soon?
Oh, you do? Hang
Yes.
on. Do we think we had an agreement or?
So I know a heart assistant.
Hang
they
on,
told
hold
me.
on, Mr. Winner. Mr. Winner, hold on.
Okay.
Yeah, I'm honestly not sure, Judge.
You want me to kick it out a week?
Uh,
I know you don't want to, but I know, I want to make sure he gets to his physical therapy.
yeah, go ahead. That's fine.
All right. All right, Mr. Gwinner, here's what I'm gonna do. I'm gonna adjourn your case out one more week, okay?
Okay.
Because I don't want to hold you up from having you wait and hold you up from getting to your physical therapy. So I'm gonna
Okay.
adjourn it out to 27, 2026 at 1 p.m. Okay?
Yeah, and I have a question, Your Honor. If I get it paid before that, do I have to show up still?
You get it paid before then? No, you do not.
Okay, that's the plan, to have it paid before then.
I get you. Okay.
All right,
Okay,
thank
get
you.
to your appointment. You hear me? Mr. Gwinner?
Yep. Yes.
Okay, get to your appointment. We'll see you next week if necessary.
All right, thank you. Would it be in person or Zoom?
It'll be in person if you can make it, otherwise file your Zoom request.
Okay, thank you.
All right, thank you.
Your Honor, just for clarification, we did not have terms on that one, and I don't think we expected him to be on Zoom today. That's why that's.
Gotcha. Right, I did that because of medical issues for him.
Sure. What was the time and date, Your Honor?
I set that next week at 1. Right. Peninsula Place versus Brandon Bowe.
Robert Visconti, P61756 for the plaintiff.
Brandon Bowe. Okay, did we get our numbers?
Your Honor,
That one is 670.
One of the ones he said was in.
I don't think so.
I don't have them in Zoom.
Oh, yeah, no, we did have a consent judgment. We expected him to be in Zoom today.
Oh, I see what you're saying.
No, we told him he had to log in.
Yeah, he's not here. But what I will do there was a consent that was signed.
Yes, sir.
I'll take it as a consent or I'll take it as a default, either way.
Your Honor, I'll do it as a default
All right,
on a different order with the same terms.
got it.
Rent to retain, Your Honor, is $1,479.70. Costs are $177.72 for a total of $1,657.42. No writ shall issue, and this is set forth in paragraph 10. If defendant pays $700 by March 30th, 8/12/21 by April 10th, 8/12/21 by April 24th. That includes rent and late fees through the month of April. These are the terms that were agreed to with Mr. Bo. We'll enter that as a default.
All right. And if you could raise your right hand real quick for me. You solemnly swear from testimony you've given and testimony you will give is true to the best of knowledge and information with it. All right. I'll grant judgment to the plaintiff that is by default pursuant to the terms as placed on the record and contained. Court calls case People versus Darian Fritz. Like everybody else we have.
Robert.
Your name, sir?
Darian Fritz.
Thank you. All right. Where are we in this?
Proposed consent.
Yes, sir.
Reflects rental rate of $322.28, cost of $177.72 for a total refund of $500. Defendant's going to pay $100 by April 3rd, $400 by April 17th, and April late fee by May 1st. Failure to do so will allow an order issue. We do have an order prepared and signed by both parties.
All right. Sir, is all of that correct?
Yep.
Do you have any questions regarding this?
No.
All right. And you did explain his rights under 4.201J.
Correct.
All right. Judgment by consent along those terms. I've entered it. You're all set, young man.
All right. Thank you.
Court calls the case of Peninsula Place versus Anthony Miller.
Wisconsin P617556. Plaintiff.
Your name?
Anthony Miller.
Thank you.
Consent judgment, Your Honor.
All right.
Possession only. Rents retained in this case is $1,260.51. Costs are $177.72. Totals $1,438.23. Judgment for possession only with the writ to issue after March 30th, if not paid in full.
All right. Is that correct, sir? All right. Do you have any questions whatsoever regarding the terms on this?
Yes, sir.
Think you're going to get this paid by then?
Yeah.
Okay. All right. And the box isn't checked, but you're here without counsel, sir. You have 3 business days to think about this. If you have some legal reason, some right you didn't assert, or some misunderstanding or confusion regarding the terms of this judgment, you have 3 business days in which to file a motion to set this aside. Doesn't mean that I would, but you have those 3 business days to do that. You understand that, sir? All right, very good. I've entered the judgment. Thank you. Peninsula Place versus Elijah Bowe. Boy.
Robert Piscani, P617556 for the plaintiff. I think we were expecting Mr. Boyd to be present on Zoom.
He is not checked in.
So we'll do his consent terms by default, Your Honor.
Go ahead.
Rents retained in this case is $2,663.79. Costs are $177.72 for a total redemptive amount of $2,841.51. No writ to issue $600 by March 30th, $1,464.25 by April 9th, and $1,464.26 by April 23rd. And that does include charges through April and charges through April.
Print to the plaintiff by default for possession. Redemption amount is in the amount that is requested. Go to the term says stated. Court calls the case of Peninsula Place versus Ashley Wang. She's on.
She present?
Yes, she's
Hello.
just muted her. Hello, Miss Wang. Yes, she's present.
Good morning, Your Honor.
In your honor, we have a proposed consent judgment. Wang to pay her balance in full by April 30th. Rent to retain in her case is $1,887.17. Costs are $177.72. Total redemptive amount of $2,064.89. Again, judgment for possession only with writ issue. If not paid in full by the 30th, I would have to ask Ms. Wang if I have permission to sign her name to her.
And the writ date is the March 30th. You said April 30th, March 30th. All right.
Yeah, it should be March 30th. We were just had a conversation the other day with the landlord that I'll be able to pay before March 30th.
You'll be able to get it paid before March 30th?
I mean, no, on the March 30th is my date that we were had a conversation with the landlord a few days ago.
So the agreement is you'll pay that amount by March 30th, correct? On or before March?
Yes.
Yes.
Okay. All right. Very good. Did you have, and Mr. Visconti has permission to sign your name to the consent judgment, ma'am?
Yes.
Okay. And ma'am, you are appearing before the court. You're unrepresented by counsel. You have 3 business days in which to think about this consent judgment. If you believe that there's some legal reason, some confusion on your part, some misunderstanding, you'd have to file a motion with the court within that time frame. Doesn't mean that I would set this aside to have those 3 business days to think about it. You understand that?
Yes, I do.
All right. Thank you very much. We're all set. I've signed the judgment. If you want a copy, you can come up to the court and pick one up. All right?
Just making sure, is that okay? The last question. You say March 30th is the deadline, correct?
Pardon?
Is it the March 30th is the deadline? Is that correct?
At 9? No, March 30th. You just have to get everything paid by that date.
Okay, perfect. Yeah, just wanted
Okay,
to make sure.
you don't have to come back and see me. Not that we wouldn't want to
Okay.
see you. You don't have to come back.
Okay.
Okay?
Okay.
All right. Thank you.
so
Peninsula Place versus Ariel Fisher.
Plaintiff. I believe we expected Ms. Fisher on Zoom.
She's not checked in.
She's not checked in. That's Holly. You know how I can tell? You know how I can tell? Because I saw her face on the screen. I saw her walk in. That's Holly. Saw her out there. We had a Holly sighting. All right. Just thought I'd point that out. Hello, Holly. He's like, I'm so embarrassed. My God. All right, go ahead.
We'll enter the consent terms by default, Your Honor. Rent retained $97.28. Rent costs are $177.72 for a total redemptive amount of $1,075. No writ will issue if defendant pays $300 by March 30th, $552 by April 10th, and $1,000 by April 30th. That excludes April rent late fee. You have an order prepared.
All right, great. Judgment to the plaintiff. That is by default for possession. Redemption amount. With the redemption amount as indicated and with payment terms as indicated on the judgment, the court will sign. Court does call the case of Peninsula Place versus Xavier Townsend.
Robert.
Name?
Xavier Townsend. All right. We have a consent judgment, Your Honor.
All right.
Judgment reflects a rental arrears of $3,776.51 through the month of March. Cost of $177.72 for a total redemption amount of $3,954.23. Order provides that a writ may issue not comply with the terms of paragraph 10. Paragraph 10 states the defendant must pay $2,000 by April 3rd, $1,000 by April 15th, and $954.23 plus April charges by April 30th. Failure to make any payment would allow a writ to issue.
All right. And man, is all of that correct?
Yes, sir.
You have any questions regarding anything contained on this judgment?
No, sir.
All right. You're here without counsel. I do have to advise you have 3 business days to think about this. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court within those 3 business days. You understand that?
Sir.
I mean, I'd set it aside, but you have that time and week to do so.
Okay.
Got it? All right, take care.
Hi, sorry to interrupt. I was wondering if I'm in the right place.
You are. My staff tells me you are. Which complex is she? She's part of Peninsula Place. Yes, ma'am, you are. We just haven't gotten to your case yet.
All right, just checking. Thank you.
Oh, you're welcome. Peninsula Place versus Landon Brooks.
Robert Visconti.
Your name?
Landon Brooks.
Thank you.
So, Your Honor, we do have a proposed consent judgment in this matter as well. Rent to retain in this case is $2,948.06. Costs are $177.72 for a total of $3,125.78. Paragraph 10 of the order provides the defendant shall pay $1,200 by March 30th, $1,200 by April 17th, and $7.5 plus April rent and late fee by April 30th. Failure to make any payment would allow a writ to issue. And we do have a signed order.
All right. Young man, is all of that correct? You have any questions or seeing anything contained on this? All right, I do see the boxes checked. You were advised of your right to rescission 3-day business. All right. Well, enter that judgment. All set. You need a copy, you can pick it up at the front counter. Court calls case of Peninsula Place versus Maya Manning.
Robert Visconti, the plaintiff.
Hello,
Hello,
what's your name?
Maya Minnie.
All right, where are we?
Your Honor, we do have possession only in this matter. Rent to retain is $2,668.47. Costs are $177.72 for a total of $2,846.19. Judgment for possession only with an order of eviction to issue if the defendant does not pay that amount or vacate by March 30th, 2026. And just to disclose, Ms. Manning did advise me that she does intend to vacate. Advise her of her rights, the box is checked.
Ma'am, is all of that correct?
Yes.
You have any questions regarding this judgment?
No, Your Honor.
All right, very good. And I have signed the judgment. If you need a copy, you can pick one up front at the counter.
Okay, thank
All right, thank you. Court calls case of Peninsula Place versus Promise Johnson.
Robert County, P61756.
Hello.
Hello.
What's your name?
Promise.
All right, where are we?
Your Honor, we have post consent judgment possession only in this matter. Collection rent arrears of $2,084.51, cost of $177.72. Total redemptive amount $2,262.23. Again, possession only with written issue if the defendant fails to comply with the terms of paragraph 10. Paragraph 10 states the defendant shall pay $1,100 by March 30th, $762.23, and April rent and late fee on April 30th, 2026. The order is signed by both parties, and Ms. Johnson wants to advise the relationship.
Promise, is all of that correct? Is? Do you have any questions regarding anything contained on the judgment? And you did understand your 3-day right to rescission? All right. I will enter that judgment. I've signed it. If you need a copy, you can pick one up front at the counter. Okay. All right, thank you. Court does call the case of Peninsula Place versus Devontae Hughes.
Robert Visconti.
Hello, what's your name?
Devontae Hughes.
Your Honor, we have post consent judgment for possession only in this matter. Rent retains $486. Costs are $177.72. Total redemptive amount $663. Possession only with after the 31st, if not in full. And use what the resident right for students, therefore 4.2.
Well, is all of that correct?
Understood.
Gonna be able to get that paid?
Yeah, next week.
Yeah, you had no questions, correct? All right. I've signed it. Thank you.
Appreciate it. Have a good one.
Take care. Peninsula Place versus Jace Johnson.
Robert Biscampi.
Hello, Your Honor.
Hello, what's your name?
It's Johnson.
You're in school?
Yes, sir.
What are you studying?
Criminology.
Yeah. Something just told me that. I don't know why. All right. What are you gonna do with that degree?
Trying to become a prosecutor.
Why?
You know,
Why do you want to be a prosecutor?
I don't like defending people, honestly.
Oh, so you know what? My sister is the chief public defender for Washtenaw County, just so you know. I'll let her know what you said.
Yeah,
All right. I'll just, okay, don't worry about it.
All right.
Okay, and take down his name. All right, we got his address. All right, go ahead. What are we doing?
Your Honor, we do have a proposed consent judgment with Mr. Johnson. Rent retained in his case is $1,603.47. Court costs are $177.72 for total redemption amount of $1,781.19. Pursuant to paragraph 10, defendant shall pay $700 by March 30th, $700 by April 6th, $381.19 in April rent and late fee by April 30th. Failure to make payment timely would allow an order of eviction to issue. He goes advisor's right. Sir 4.201J, and the order is signed by.
All right. Mr. Future Prosecutor, is all of that correct?
Yes, sir.
All right. Do you have any questions regarding any of this? Or?
No.
I've signed the judgment. I've joked with you, but I wish you all the best in the future.
All right, thank you.
All right, take care. All right. So I have the rest of your stack. Did you need more, Mr. Sante? If you, it's obviously being very productive. If you need more time, I'll give that to you.
I think we've actually got 3 more consents to put on the record, and then I think there were a couple of folks who did not want to enter into consents.
Got it.
So I think we can keep rolling if you'd like.
Yeah, I'm fine.
And then defaults.
Right.
Stuff for last.
I gave you the people who had checked in the next few.
But he's got 3.
I can tell you it's 693, 696.
Oh, okay. You better.
717 that are consents.
Thank you. Peninsula Place versus Fatima. Is it yeah? Oh, she's the one that traveled all over. She still got a consent? Yeah. I love young lady. What's your name?
Fatima Diop. My last name right. I'm shocked.
I did say it right?
Yeah.
See? I knew that. I knew that. Okay, that was just happenstance. I didn't know talent sometimes. All right, thank you. What do we do?
Your Honor, we have post consent judgment for possession only in this matter. Rent retains $1,568. 77.72 for total redemption amount of $1,745.93. Pursuant to paragraph 10, defendant shall pay $600 by March 30th, $600 by April 13th, $540 fee by April 27th, and April rent late fee by April 30th. Fitted timely would allow an order of eviction to issue, order signed by both parties and.
Ma'am, is that all of that correct?
Yeah, I just have one question though.
Did you have a question? Go ahead.
The April 30th, is it the late fee and April's rent as well?
Yes.
Okay.
Pay up all accrued charges from there.
Okay, all right.
You think you can do that?
Yeah.
Yeah? Okay. Any other questions that you have? And you understood your 3-day rights of rescission?
Mhm.
Okay. All right, you've entered the judgment. If you need a copy, you can pick it up front at the front counter. All right, you take care. Have a great weekend. Peninsular Place versus Michael Pugh.
And we do have a proposed consent judgment in this matter, Your Honor.
All right. Your name?
Michael Pugh.
All right.
And pursuant to terms of judgments, there is a rental arrearage through the month of March in the amount of $2,878.39. Cost of $177.72, total redemptive amount $3,056.03. Pursuant to paragraph 4, defendant does not comply with the terms of paragraph 10, a writ may issue. Paragraph 10 states the defendant must pay $1,000 by April 3rd, $1,000 by April 7th, and $1,056.03 plus accrued charges for April by April 30th. And if failure to make any payments timely would allow an order of eviction to issue. Defendant was advised of the rights pursuant to MCR 8.201J, and the order is signed by both parties.
Is all of that correct?
Yes.
All right. Do you have any questions regarding anything on this judgment?
No.
And you did understand your 3-day right to rescission?
Yes.
You in school?
Yeah.
Studying what?
Digital media production.
Digital media production?
So like film production.
What?
So like film production, like movie production.
What are you going to do with that?
I want to be a director.
Really?
Yeah.
You like running people's lives? Me too. Don't worry about it. You're good. All right. All right. Yeah. I've signed that judgment. You can pick up a copy up front at the front counter. Take care. Peninsular Place versus Timothy Frank. What's your name?
Timothy Frank.
You in school?
Yes, sir.
Studying what?
Marketing.
Yeah, people do that. I don't know that. Go ahead, Mr.
We have a proposed consent judgment in this matter. Rent to retain is $3,592.96. Costs are $177.72. Total redemptive amount $3,770.68. Pursuant to paragraph 10 of the order, defendant shall pay $1,200 by March 30th, $1,500 by April 13th, and $1,070.68 by April 27th. And finally, April rent and late fee by April 30th. Failure to make any payment timely would allow an order of eviction to issue. Frank was advised that his rights pursuant to MCR 4.201J, and the order is by both parties.
All of that correct?
Yes, and I also they did tell me by like the 30th if I wasn't going to be able to pay like the late fees or whatnot. They told me I can go to Holly. We can figure something out to give me more time. So with that being said, would I have to come back to court like if I needed more time?
Okay. So I want to make sure I understand your question. You're to pay everything, the accrued charges through April by April 30th. Is it the 30th? April 30th is the date you're worried about?
Yeah.
And so if by that time you have everything else is paid, but it's just the late fees and other charges that you can't pay.
Yes.
All right. Is that truly part of the agreement or?
I have
what?
Sorry, Rebecca Austin, also for plaintiff.
Yes.
I told him if he could pay the pass through arrearage by the 27th, but he can't come up with April rent by April 30th because it's a 3-day window. If he goes to see Holly, sitting in the front row, and our property manager, he would extend him another courtesy to give him a little more time if he get that 3,700 caught up by the 23rd.
Okay.
We won't evict him for April rent.
For April rent, where you're trying to get that.
Okay.
But there will be another court case. To your question, you won't have to come back. It's already
Right.
Okay.
Unless you want to come back and see me.
Oh no.
No, what? No, that was quick. No, he's like, no, I'm good. All right. Okay. All right. Did you have any other questions, young man?
No, sir.
All right. So really, what are you going to do with that degree?
Really, I plan on opening up my own gym and really just getting a corporation job. So.
Really?
Yeah.
Big. Gonna open up his own gym.
Mhm.
You won't see me there. All right, I'm just letting you know. All right. I mean, I'll come by and say hi, but
Hey, that's true.
you want to throw me on one of those machines? That's probably not tonight. All right. Again, I signed the judgment. If you want a copy, you can stop out at the front counter.
Thank you.
All right. Take care. All right. That's Pardon, the next person is here. Peninsula Place versus Amy Diagne.
Yes, I'm
Sure.
here.
All right, I'll need a cameraman.
Yes.
Are we ready on that or?
Uh,
Hold on a second.
What are the last three?
Last three are 7:05.
Down in the file. Robert Visconti, P 61756, the plaintiff.
All right. And where are we on this case?
Looks like we have a proposed consent judgment.
It's all right.
$503.40. Costs are $177.72 for total redemptive amount of $1681.12 pursuant to paragraph 10 of the ordinance over dollars by March 19th, $881.12 by April 2nd, and $797 by April 18th. This includes April.
sorry, it kicked me out. Could you please repeat?
Yeah, you're gonna start again. She dropped, but she came back in.
All right. So the judgment reflects rental arrearage of $1,503.40 through the month of March, cost of $177.72, for a grand total of $1681.12. And the agreement of the parties is that will be repaid as follows: no writ to issue if defendant pays $800 by March 19th, $881.12 by April 2nd, $797 by April 15th. This does include April rents and late fees, and any missed payment would allow an order of eviction to issue. I would ask the defendant if I have permission to sign her name to the order before I submit to the judge.
All right. Ma'am, is all of that correct?
Yes, that is correct. But there's one thing, concern I had. So yesterday I submitted a payment for March 19, but it wasn't fully complete. It's missing $385, which I am planning on paying today. And it is a day late. I wanted to know if I can still make the payment, or is that causing, like, I was just trying to figure out, like, because I couldn't pay.
They will take your money.
We'll accept that.
Okay.
All right.
Okay, because my mom was
all
supposed to
right.
send it to me, but I can submit it today by the end of the day.
All right. Okay. Any other questions you had, ma'am?
No, that was it.
All right. You did understand your 3-day right to rescission.
Yes.
All right. You are giving Mr. Visconti permission to sign your name to the judgment?
Yes.
All right. Very good. Okay. As soon as I have it in my hands, I will sign that judgment. If you need a copy of it, you can stop by the court and pick one up. Okay?
Okay. Thank you.
All right. Thank you.
Bye-bye.
Anybody else we know here, or just the one that requires the interpreter is from
It'd be 701 and 710 are both here. Singleton and Jerry.
701 and 710. Court does call the case, Peninsula Place versus Taylor Singleton.
Robert Visconti.
Oh,
Hi,
what's your name?
Taylor Singleton.
All right. You in school?
Yes.
What are you going to be?
I'm studying public health, getting my master's, so healthcare administration more than likely.
You were the one at U of M?
Yeah. Yes.
Yeah. You were the one that just kept talking to me.
Yes.
Yeah, okay. I remember. All right. Okay, fantastic. Go ahead.
Your Honor, we don't have anything worked out on this matter with either myself or my colleague.
Okay, is there a reason for that, ma'am?
Yes. I spoke with Holly yesterday, just going into the leasing office to try to work something out, but we just weren't on the same page with the charges.
Okay, when you say you weren't on the same page with the charges, what do you mean?
So as I expressed last time, that the charges on my account were incorrectly billed, specifically some of the VCR charges.
Some of the
VCR, that is for utilities, with that is what the property will charge you if you don't have utilities set up into your account. So that is what I was charged, and I did have utilities within my name.
Okay. And anything else that you think was improperly charged?
No, specifically the utilities, that's what I was charged for. They gave me a ledger for my account, and I highlighted the charges on the account for the VCR. And yeah, that kind of just adds up, but this came from Peninsular Place, and the property manager
Okay.
also has a company.
How much are those charges?
The charges on here amounts to roughly $386 when I added them together. And then I had 2 late fees on that were questionable, but
So $386.
$6.
Too late. What's the total?
$60. Can I pull out my phone because I actually
Sure.
had an
Go
order.
ahead. $60.
So it was actually, my apologies, $366.83.
356.83.
366.83.
Got it. And late charges totaling how much?
$60.
Okay, so give me that total. That's $426 basically that you're disputing.
Correct. And then that has just been accumulating over time. At the end of my ledger, so with that price in mind, at the end of my ledger, it says $479.30. So I'm not sure where that remaining came from. But that has just been accumulating because this was from January. So we're now in February or March.
All right.
So yeah, so
What was accumulating?
the balance due to late fees, basically. So when speaking with the property manager,
Hold on.
okay.
If I take the 426 or whatever figure you want, let's say I just took $500, or I just took $500 off, there's going to be approximately 6,500 plus 6,600 that's owing. Is that right? What do you have our balance on?
No, the total balance right now through the month of March is.
You know what? They have an extra one in there. Go ahead. What is your thing?
Total, it would be, the total balance right now inclusive of court costs is $513.56.
$513. All right. Thank you. So when you say somebody explain to me these charges then.
I can explain.
Go ahead.
Okay, so starting from the top, I have my leasing agreement. So the lease, my rent each month, that includes my rent and parking, is $674. Actually, where is my, sorry. So yeah, here it is. So I had a leasing for $674 billed each month. So with that, that doesn't include the sewage and the water, which is no more than like maybe $30 additionally. So when doing my payments or paying on my account, I charged $700 each month, which I do have bank statements for as well. But looking at the ledger, it didn't really align with what I had paid. So those charges are kind of a little bit all over the place. But also when speaking with Holly, trying to figure out exactly where the additional charges came from, because she said, well, if I take away the utilities, you still owe X amount of dollars. So again, going back to the leasing agreement, it says if your balance is over $100, then you will be charged a late fee. So I didn't get charged a late fee on my account until December, which I was late on my rent. I paid it. That's a $60 late fee because you get a $30 late fee every 5 days. So I got one on December 5th and I got one on December 10th because I paid it December 20th. So I don't know why they didn't give me another one, but the fact of the matter is that I didn't start getting a late fee until December. And then looking at November, I got charged for the VCR. So that means in December, I was already going to face a late charge because I was incorrectly billed the previous month. Moving forward, then with the...
You say you were previously billed?
For the VCR charge, that's what I mean. So for the utilities. So
Somebody explain to me this.
right. So also with the utility.
Yes.
Yep, please.
First of all, I'd like to note that my client purchased the property on January. So a lot of what happened here happened before current manager.
I'm aware of that.
The VCR charge that is added to the account, you can correct me if I'm wrong, which I probably will be. The VCR charge is added to the account in the event that utilities are not properly placed into the resident's name. Is that correct?
Okay.
So that is where the charge arises. Typically, it's like the property is billed and then it's a bill back.
Correct. So when you went in and spoke with Holly, did you show that you had the utilities in your name on a particular day?
Yes. So also here it is. I also have a document for the DTE utility. So for the previous property manager, her name was Jane. I informed her before Holly got into this position that I had already had utilities.
I asked questions for a specific reason.
Okay.
All right. So I just need you to answer the question.
Okay.
Go in and did you show Holly something that said I had these in my name as of a certain date?
No.
Okay. So if that's not presented, and you know that they just came into this position, right?
Yes.
So if you don't present something that says the utilities were in my name as of whatever date, and so I shouldn't have this charge, how's she supposed to do anything for it?
So to answer your question, I did call to relay this matter, and Holly was
call who?
The Peninsular Place, the leasing department, the property manager. So I called one of the agents at the leasing office. So she was aware because I told someone at the leasing office. And
okay, lady.
Okay.
You're saying that you were improperly charged these things.
Right.
You were improperly charged these things because the utilities were in my name at a particular time.
Right.
Okay. So you go in and you talk with Holly, you go in and talk with Peninsula Place, understanding that they weren't there at some point, right? They have these charges on your account, right?
Right.
How are they supposed to do anything for you if you don't show them something that says, yes, what I'm telling you is true, because here's when it went into my name?
So I reached out to the last property manager, American Campus Communities. I'm responding to your question by saying,
no, you're not.
No, because she was in by the previous property manager.
She what?
She was informed by the previous property manager.
But there's maybe a reason they're not there. So why wouldn't you just get the documents and just show them to? I mean, I don't get why this has to be so hard.
Well, guess I'm just confused on what you're asking, because I did inform her and show proof that it was in my name.
Look. These are utilities through DTE and who else?
Just DTE, and there's a charge that.
I'm sorry?
This charge for DTE.
DTE.
and a charge that some previous company had placed on the accounts for not having used the properly.
Right, but it just utility company. Okay, so let me ask you this, young lady. Why wouldn't you just go to DTE, say, when did this account go into my name? Get that document and then give that to them to say I was improperly charged. Wouldn't that be the easy way to solve this?
I did. However, the property was sold, so I was not reimbursed on my account for that. And I have that right here as well,
You have what right here?
stating when I started my DTE and the months that I've been billed
You
as
have
well.
something from DTE said
Yes.
that? Did you
Yes.
show that to her?
I showed, not her specifically, but American Campus Communities, because that's who I was settling it with at the time.
Okay, but when you went in and talked with Holly, I really am not getting this. Why wouldn't you just show her what you have that says I had these utilities in my name as of this day? And that these charges are improper? Why wouldn't you show that to her?
And because when I was having a conversation with her, she provided me with a ledger of what I was charged from the property. So there was really no negotiation as it relates to DTE. Besides the fact that she informed me that they are aware that I was incorrectly billed and that the unit in which I was paying for is being refunded.
You understand. I think they're in agreement with you that if it's in, they shouldn't have been charged. Am I correct?
Yes.
Okay. So I'm still not clear why you wouldn't just show that to them.
Because they know.
Okay, so here's the thing. They may or may not know. I don't know, but it's more persuasive to me if you went in there and said, Holly, here this is. I'm showing you this. I don't think I should have been billed this. And then they do nothing.
She informed me that they're actively.
Okay, so here's the deal. I can set this for trial. All right, because you don't seem to want to do what would make sense. I can set this for trial. You come to trial, you make the same claims that you've been making to me for these past 2 times. I'm going to say, show me proof that that's the case. Right?
Okay.
The proof that I'm going to accept is something from DT that says when you put it in your name, which is the same thing that they may need. Right?
Correct.
So why wouldn't you just do that now?
Your Honor, because they are aware of that.
I don't get it. What if I did this? What if I just ordered you to give them a copy of their DTE bill that shows when you put it into your name? Are you going to disobey my order because somebody told them?
No, Your Honor.
Okay, then that's my order. You need to get a copy from DTE of when it was put into your name so they can look at it and they can try to adjust your account if it's appropriate. How long is that going to take?
End of day.
How about you this to March 27th, 2026? What time? 1 p.m. That's in person. Thank you. I hurt my head. I did. when it fell to the bench. Yeah. I don't even know where I am now. I just don't, what? I don't want to call anymore. And
Just wait,
Peninsula Place, what?
get a load of this one.
Okay, Peninsula Place versus Travis Jones. Your name?
Travis Jones.
All right. Have you guys got an agreement?
Mr. Jones has been CR, it's still pending, so. Attorney.
Okay. That's easy. I could do that. All right. Have they given you any indication when they?
Yeah, I actually have an appointment today. I was waiting on my phone call. So.
Oh, for that?
Yeah, for my appointment, yeah.
All right.
No documentation, all that.
Did you get over to Hawk also or no?
They weren't, I submitted documentation, so I'm still waiting on them too.
He wasn't one of ours. Okay. All right, I'll adjourn this to March 27, 2026 at what time? 1 p.m. So you'll be back for our other thing. Thank you, sir. Should have called that one first. All right, Visconti, anything else? Or do you just?
I think that's everybody who's here.
That's everybody that's here?
As far as I know.
No? Yeah, one. We have the one with the first interpreter. Let's do that.
Good afternoon.